Just bring the,
My stitch.
all right, thank you.
Sorry.
All right, everyone, please be seated. Defense, you may call your next witness.
Yes, Your Honor, the defense calls Richard Thomas.
All right, can you raise your right hand?
Yes.
Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. Make sure you keep your voice up so that the members of the jury can hear you and the court reporter can hear you. All right, if you state your name for the record.
Richard Anthony Thomas.
All right, defense.
Thank you, Your Honor. Mr. Thomas, could you describe for the jury your relationship, if any, with Nina Sanchez?
As of right now, or
Let's back up a little bit.
okay,
Let's talk about when this allegation started.
my relationship with her, really didn't have one. I was kind of distant from her and Jacqueline.
Tell you what, let me ask you this. Were you strict on them?
Oh yes, yeah.
Why?
For one, that's the kind of parent that I am. But for two, I think I didn't want a relationship with them. I had left I separated from my wife, and I left my daughters and my son behind. And I think I kind of took it out on them.
So you're not surprised that Nina hates you?
Yeah, no, not at all.
I'm gonna switch it a little bit because I'm gonna get to the point. Did you do what Nina said that you did?
No, sir.
Did you touch her inappropriately?
No, sir.
Did you have a sexual relationship with her? Did you steal her virginity from her?
No, sir.
In fact, tell the members of the jury, how is it that you came about on giving this infamous confession?
I remember that they removed my children from the house. I believe I came home. My wife told me, or my wife called me, and I believe they spoke to my wife first, the CPS, and then they said if I would,
Objection, hearsay.
Overrule.
um, they said if I was willing to go in and give my statement. So I didn't have a problem with that. So I went in and talked to Miss Belinda. Right off the bat, she was very rude. She treated me like I was already guilty. I explained my side of the story. I told her none of that never happened. And obviously she didn't believe me.
And so to prove your truthfulness, you submitted to a polygraph test, is that correct?
Yeah, she recommended a polygraph test, and
Explain to the jury how that polygraph came about. What happened in there?
I know they asked me, I don't remember the questions, it was very long ago, but
Did they ask you to lie?
I believe so.
And so you had to lie.
I think, yeah,
And then they asked you whether you have lied in the interview.
correct.
And you told them,
No,
and so that's a lie.
correct.
That's the polygraph base of supposedly telling you that you failed this polygraph.
Yeah.
Were you truthful in this polygraph?
Yes, 100%.
And did you tell him at any time that you touched her, Nina, in any way?
No,
But then Mr. Martinez comes back and says, you failed the polygraph test.
correct.
May I approach you on it?
Yes.
Now, we have what the state has introduced into evidence, the only piece of evidence introduced in this case. And voila, a polygraph test leads you to write that or sign that.
I signed it.
So you didn't say, hey, by the way, this is what I did. They told you what you did
Correct.
and you signed it.
Yes.
Please look at the members of the jury because they're deciding your fate. Why in the world would you do that?
Well, first of all, I was told that I failed the lie detector test, which I found out that wasn't correct. So I felt in order for me to get my children back, if nothing I said, that they would believe me.
So you signed that document
Correct.
under duress.
Yes, sir.
Now, Brojan,
Yes.
I noticed something very interesting in that document. Because when you submit a statement, all it requires is your signature, correct?
Correct.
Whose signature is right below yours?
Belinda.
Why would her signature need to be there?
Objection, speculation.
Sustained.
And then what would you have to have a witness?
Objection, speculation.
Sustained.
I tell you what. Was that statement what Nina recanted later on?
Yes, sir.
And so, which is why you were not charged.
Correct. They dropped the charges in court.
So we know that she recanted something,
Yes,
and that's what they had against you.
correct.
May I approach, Your Honor?
Yes.
Here we are. Tell the members of the jury. When was this statement taken?
In March the 1st, 2007.
2007. How many years is that? Let's do this together. 2008, 2009, 10, 11, 12, 13, 14, 15, 16, 17, wait, 18, 19, 20, 21, 22, 23. How many years is that?
23.
No.
Oh, I'm sorry.
By the way,
16 years, I'm sorry.
do you graduate from high school?
No, I didn't.
Do you have a GED?
No, I don't.
Did you feel powerless in front of all these people? The detective,
Most definitely.
Belinda,
Well, yeah, because I've never been CPS. I'm
you have no education, correct?
correct.
You never had any occurrences with the law before.
No.
This is just the only time,
Correct.
and you felt trapped, didn't you?
Most definitely.
16 years. Here we are. Why are you wanting to tell your side of the story to the jury?
Because I believe that there's there's more to it
Objection, Your Honor, to what the defendant believes.
Overruled.
because there's a lot more to the story than just this confession
Nina tells stories, doesn't she?
all the time.
And most of them are pretty credible.
Objection, improper impeachment.
That'll be overruled.
Yes, she does, many times, and I'm not the only one that she's ever said that touched her or.
Now I want you to again look at the members of the jury and tell them, did you touch Nina in any way inappropriately?
No, I didn't.
Did you have sex with Nina any time?
No, I didn't.
Did you break her virginity to the point that she was bleeding in the sheets
No,
in your room? Did you ejaculate in that bed right next to her?
no,
Have you ever walked naked to grab her?
no,
You ever walked naked in front of your children
no.
with her? Mr. Thomas, why are we here?
Because every time that I gave my side of the story, nobody ever believed me.
Here we are yet one more time. And may I approach your honor?
Yes.
What the jury is gonna have in front of them is this. Why would you do that? Why would you confess to something that you didn't do?
Because when I told them the truth, it didn't get me nowhere.
So now you lie and then your children are returned to you.
Correct.
Was that a relief?
How big we?
Let me ask you a question. In hindsight, would you have done it again if the state would have taken your kids?
Oh, yes. I mean,
Why? I mean, here you are facing a jury of 12 people.
because at that time, I wanted my children back. And I didn't know what was gonna happen next.
But if you didn't do it, why in the world would you say you did it?
Because every time that I told Belinda or I told anybody, it seemed like it didn't get me nowhere.
The investigator, did he ask you to collect sheets of this blood supposedly that was all over the place?
No,
Has anybody other than the polygraph asked you to submit to some kind of treatment?
no,
Mr. Thomas, 2007, you make a pseudo confession to get your kids back, and we're here. How does that make you feel?
Objection, relevance.
Overruled.
uh-huh. It's hard. Because I don't know. I don't know what would happen, what's gonna happen next. And it seems like every time I told my side, or I never shied away from CPS, I never shied away from the detective. I always went in and gave my side, and time after time, I it didn't get me nowhere.
You were the suspect from the very beginning, weren't you?
Yes,
And you were their target.
yes,
To this day, you're still their target.
correct.
Because now they're gonna show the jury that you confess. You lied in that confession, didn't you?
Yes,
In fact, that's not even your confession, that's Belinda's confession. Is that correct?
correct,
You just signed your name because you wanted your kids back.
correct. What was told by the one who conducted the lie detector test, if I wanted my children back, that I have to be remorseful. I have to call Belinda and let her know that I want to confess. And,
Even though you did not do it.
and he told me that I had to be.
Objection to use, Your Honor.
Sustained.
Now, this is your chance, Mr. Thomas, to tell people that will bring finality to this case. These 12 individuals right here. I want you to look at them in their face, in their eyes, and tell them your side of the story.
I never touched Nina. I can understand why she hates me. I didn't treat her or Jacqueline the way a stepfather should have. And I did fail them in that part. Looking back at it now, I wish I could have. I wish I could have treated them better. But I was going through my own thing at that time, and it doesn't make it right. But with me and Jacqueline, I was able to patch that up with her. I've been in her life for 21 years. And
At this point, Your Honor, we're going to object to narrative.
Overruled. You can continue.
and I wish I had that same opportunity with him. But there's a lot more to the story that why she would run away, and it wasn't just the fact that
Object in response to the question.
That will be overruled.
it was the fact that yes, I was hard on her, but I would punish her for lying and stealing or doing things at school. She got older. She wanted to do certain things that I didn't approve of, having boyfriends or girlfriends.
Objection under Rule 412, Your Honor.
Sustained.
Did you blame Nina?
Blame Nina for it.
You here in front of a jury. Did you blame Nina?
Yes and no.
Explain that to them, because again,
I don't blame her because of how I treated her and her sister. But the thing is with Nina, she would always go over and a lot of the things she would do.
let me make sure I get this straight, because the jury's listening. How you treated Nina, did that include sexually touching her?
No,
What do you mean by how you treated Nina?
just the way I was always on her. And every little thing that she did, I would punish her.
Is that why she hates you?
I'm pretty sure, yeah.
So I'm gonna ask you again, do you blame her?
No.
But the other side of that question is, was she truthful when she told the jury that you did whatever you did to her sexually?
Oh, no.
How can you ensure this jury that that's not what happened?
For many reasons. I was never alone with Nina. You know, that's just something I would do.
Mr. Thomas, this is your chance to tell to the jury whether in fact you did what they say you did.
No, I didn't.
Again, how can you tell the jury?
Objection as an answer.
Overruled.
Because I never touched her. I never. Also, there was never no evidence. I mean,
Madam Pro Tem,
Yes.
I'm giving you a chance to convince the jury, but this is gonna go back there with,
Sidebar, Your Honor.
Sustained.
that. It says here that you touched her. Now tell them how you didn't touch her.
well, I never touched her at all in any way, and on this time and on any other time.
But that's your signature.
Correct. But like I said,
Objection, no question pending.
Overruled.
the reason why I did sign that was to get my children back.
I have no further questions from this witness, Your Honor.
State.
Mr. Thomas, you're telling that this jury today that you lied to CPS.
Correct.
You're telling this jury that you lied to the polygraph examiner.
Know that I told the truth. No,
That you told the truth to the polygraph.
correct, that I never touched her.
You're telling this jury that you signed that confession without reading it, without knowing anything that's on it. That's a yes or no question.
What was the question again?
Are you telling this jury that you signed that without knowing what you were confessing to?
No, I signed it knowing.
Okay, so you read that document before signing it, correct?
Correct.
You saw all the allegations that it made in there, correct?
Correct.
And you still signed that document.
Correct.
And you're telling this jury that that was a lie.
Correct.
And you lied to get your children back. Is that correct?
That's part of it.
That's a yes or no question. You lied by signing that document to get your children back.
Correct.
So you lied to benefit yourself in that
To
that would
benefit,
help you get your children back.
to benefit my family, getting myself, to get my children back. Correct.
And you're telling this jury that now they should believe you, even after you've already said to them that you would lie to benefit yourself. Yes or no?
Correct.
Now, you said that every time you've told your story, nobody believes you. Isn't that right?
Correct.
Isn't it possible that nobody believes you because you've already admitted to lying before?
Objection, Your Honor, argumentative.
Overruled.
That's a yes or no question.
What was the question again?
Isn't it possible that nobody believed you because you've already lied in the past?
No, they didn't believe me because they didn't want to believe. They didn't give me a chance. CPS didn't do, she said she did an investigation. There was no investigation at all.
Well, didn't you sign a confession saying, admitting to touching Nina?
Correct.
And you're also saying here today that you got your children back right after you signed that confession, isn't that right? It's a yes or no question, sir. I'll rephrase the question. Didn't you just tell this jury that you signed that confession and then got your children back?
Yes.
But didn't Santa tell this same jury yesterday that it was months after you signed a confession?
Objection, Your Honor, assuming facts not in evidence, may say this of the statements.
All right, so I'm gonna need you all to speak slowly so that the court reporter can write everything down. What is your objection?
Assuming facts not in evidence and misstatement of the evidence.
All right, that will be overruled.
Isn't it true that Santa told this same jury that it was months after you signed the confession
But you didn't
and
ask,
you were even back in the home?
you didn't ask if it was months. You just said if we got our children back.
My question to you now is, isn't it true that Santa told the jury that it was months after
I don't remember.
that you came back? Let me finish my question, sir, okay, please. Isn't it true that Santa told this jury that it was months after the confession that the children got back?
I believe so. I don't remember what she said.
And this case was still pending even after the children were back in the home. Isn't that correct?
No, we got our children back. It was closed.
Wasn't this case open for? Isn't it true that this case was still open in 2008?
I don't recall.
Weren't you arrested on this case in May of 2008?
Yes, that was the case that was dropped.
So you wouldn't have had contact with the children until after that case was closed.
Correct.
So you didn't get the children back right away. You didn't even have contact with the children until after the case.
I had contact with my son and my daughter.
But then you didn't get Nina returned, did you?
Her mother did. Her mother got Nina and Jack.
Mr. Thomas, if you know, who took the children from your home?
I don't know.
Would it surprise you to know that Santa, after being notified of your confession, took the children with her to her mother's house?
Sounds about right.
So nobody ever took the children from you. Santa took the children, isn't that correct?
No. That's
Isn't that what you just said?
No, I said they removed the kids. After the confession, we were able to get the children back.
You keep saying they removed the kids. Who removed the kids?
I believe it was CPS.
But you just said you didn't know.
I mean, I did know, but I didn't know who exactly. But I knew CPS had taken away the kids.
So then, when Ms. Castellanos testified to the jury that she has no power to remove the children from the home, she's lying?
Well, I don't know. I don't know her position on removing the kids or not. But I know my kids were removed from the house.
So she's saying that the children would not have been removed at the time of the investigation. That's a lie.
But what was the question again?
When Belinda Castellanos testified and said that the children would not have been removed at the time of her investigation, that's a lie.
That is a lie. Because the kids were removed from the house.
So basically, everybody else is lying except for you in this case.
Objection, Your Honor, argumentative.
Sustained.
Nothing further, Your Honor.
You know, perhaps you don't understand the term removed. The prosecutor is stating whether the state filed some kind of paperwork and then they were removed legally. But your children were taken from the house, is that correct?
Correct.
Is that what you mean by removed?
Yes.
So their children were not able to sleep in their beds at night for a while.
Correct.
Now, the prosecutor wanted you to show that, you know, Santa says
Objection,
months.
sidebar, Your Honor.
Sustained.
Isn't it true that Santa said 1 month?
I believe so.
I mean, you're under investigation. Are you stressed?
I'm very stressed.
Are you thinking whether it's a month, a day?
Not at all.
Your children were taken away and now they're brought back.
Correct.
When did that happen, sir?
When the children were
Brought back.
to be honest, I don't remember.
Why would Santa have to take her children away from her house?
And that's what we don't understand.
And that's what you're referring to remove, right?
Correct.
Now, pros, Your Honor,
Yes.
it was only after she typed this and you signed, is that correct?
Correct.
Now, your children are gone.
Yes.
Now, actually, they're gone. Now you submit this,
Yes.
and then a while back, they're brought back.
Correct.
But you just stated in 2008, you got arrested, correct?
Correct.
That's subsequent to that.
Yes.
Is that when Nina recanted her story?
Yes.
Why in the world are we here again?
I have no idea.
Nothing further from this witness, Your Honor.
So at the time that the children were removed from your home, where were they?
I believe they went with Santa's mom, I believe.
So they weren't in the foster home, is that correct?
No. Yeah,
So nobody from the state removed them.
all I know that they were removed from the house.
Where was Santa at the time?
I don't remember.
Was she able to see kids?
I believe so.
So she still had custody of the kids at the time. They just weren't living at home.
Correct.
Nothing further, Your Honor.
Nothing further, Judge.
All right, you may step down. Defense, call your next witness.
You know, at this time, the defense rests.
All right, state,
State resting closed, Your Honor.
defense, do you close?
Defense closed, Your Honor.
All right, ladies and gentlemen, I'm going to give you a break until 11 because there are some other things that we need to take up outside your presence. It's not involved in this case. Remember the court's instructions that you're not to start deliberating internally with yourself or with each other. Everything that you need to know about this case is to come from inside this courtroom. Does everyone understand? All right, everyone, please rise for the jurors. Going to print out the proposed jury charge.
You know, can I request that I get 2 copies so I can,
Oh, most definitely.
thank you, Your Honor.
Let me see. Is there anything specific that someone wants in the charge?
Just the honor about language, Your Honor, that it's explained in the jury charge.
Your Honor, and if possible, if possible, an indication in relation to polygraph and the admission or inadmissibility of polygraph examinations. I think that's relevant because that statement indicates that he submitted himself to a polygraph.
Your Honor, the state would object to that as the door. I'm sorry, Your Honor. State
All right,
does
so here's the
objection.
thing. You all can discuss it amongst yourself with regards to the polygraph. My understanding that there was a hearing that was held suppressing the polygraph,
That is correct.
but then people entered statements with the polygraph in it, and people let witnesses testify to whether or not they took a polygraph test.
That's what I believe is imperative, that we have a paragraph explaining to the jurors the law on polygraph, Your Honor.
I understand what you're requesting, but the court's question is, why would you all have a hearing on whether or not the fact that someone took a polygraph is admissible or not? Then that previous judge, which I believe was Judge Angelini, ruled it was not admissible. And then everybody is entering documents with no objection to the fact that a polygraph was taken.
Again, Your Honor, you're correct. Judge Angelini ruled against the admissibility of the polygraph. However, that was contingent on the indictment. It was an attack on the indictment. Therefore, we should have been here. But he continued us to go to trial, even though this confession was obtained because of a polygraph. That was the gist of it, Your Honor. And so because of that, it's imperative that the jury hears the law on polygraph, because this confession was obtained simply because of a polygraph test, a tool that is inadmissible in court. And yet, here we are.
So it appears as though everyone went behind Judge Angelini's ruling.
Your Honor, the state would ask that.
Oh, we're just,
Judge, we
you
did
all,
not,
here's the thing. Mr. Bias, you all can formulate your arguments, state, you can formulate your arguments, then the court will hear it.
Okay.
We're going to take a brief recess for us. The jury's going to be back at 11, but we'll be back at 10. 45. Okay,
Thank you, Your Honor.
you're welcome. You can meet us. All right. Defense. With regards to the jury charge, my understanding you wanted the presumption paragraph moved, so that will be moved, and you wanted it placed with the other paragraphs that state our law, so that's going to be changed.
As the court is aware, the court is the only entity that gives the law, and I don't see any paragraph that says our law provides.
All right.
all
All right,
persons
I'm
are-"
granting your motion on that.
Okay, thank you. Your Honor.
So now, with regards to the other issue, what is the other issue, counsel?
Is I believe that because the introduction of 2A, even though there was against the previous rulings, and again, the introduction was submitted by the state polygraph test, that I believe that the jury should hear the law on polygraph examination, and this is based on Standard v. State 802 Southwest Second 678 633 Texas Criminal Court of Appeals in
You need to slow
1990.
down so that the court reporter can take it down.
I'm sorry.
So Tanner v. State, and what is the
80
side?
802 Southwest Second 678, comma 683 Texas Criminal Appeals 1990, in which the Court of Appeals or the Court of Criminal Appeals found that the court erred in admitting that any part of the testimony of polygraph examination, such as this confession. Then Netherly, this state 692 Southwest Second 686 700 Texas Criminal Appeals in 1985, where the court indicated that only could be admissible if the parties agrees. The defense is quite adamant in not agreeing with this polygraph test. That's why we submitted court hearings early on in the proceedings. Then in Fry v. United States, this is a Supreme Court case 293 F1013, in which the general acceptance doctrine that polygraph examinations are precluded from bringing into the trial. And so because of those case law and others, Your Honor, for time and experience, I believe that the jury should be entitled to hear the law on polygraph examination, because Exhibit 2A speaks of polygraph examination. And if we don't explain the law, they're gonna presume that, well, it's a polygraph, it must be admissible. And that's where the confusion can be created, Your Honor, unless the court explains the law to the jurors. And for that reason, the defense believes that an inclusion of that paragraph of the law in relation to polygraph test should be part of the jury charge. Bless you.
All right, so defense, because I'm not the one who heard the motion to suppress, I just want to make sure that I have the sequence of events correct. The motions to suppress the polygraph examination was heard with Judge Angelini, is that correct?
That is correct.
All right, and Judge
Your Honor,
Angelini,
Your Honor.
excuse me,
There's a correction.
excuse me, and Judge Angelini granted that motion, is that correct?
The motion to suppress the confession because of polygraph examination.
Okay.
The Judge Angelini did not grant that. He says confession comes in.
The confession comes in.
That's correct.
But not the polygraph.
Not the polygraph, which is why I didn't bring the polygraph nor the examiner. So that's the confusion, Your Honor. And so the evidence.
Counsel, did you not ask in State's Exhibit number 2, State's Exhibit number 2, the mention of the word polygraph was redacted, correct?
That is correct.
And you asked that 2A be admitted, which would be
Unredacted.
unredacted. And that unredacted contained the fact that your client was alleged to have taken a polygraph.
And Your Honor, I believe you granted that on best evidence rule. That was my objection. You granted it and you said, okay.
Well, no. So that the record can be clear,
Mhm.
is you wanted the unredacted portion.
On the best.
I
evidence.
asked the state if they had any objections to the unredacted portion, and the state said no. So it wasn't the court ruling that
My
it should be
objection,
admitted.
my objection to the introduction was the best evidence rule. And so you went back to them, if you want to unredact it, and they say yes, and so, but I made an objection to the best evidence rule,
So you wanted the full,
everything,
you wanted the full document of 2A into evidence.
correct?
And that full document contained the fact that your client is alleged to have taken a polygraph. Is that correct?
That is correct, Your Honor.
And the state had redacted out in State's Exhibit number 2 that a polygraph was taken, correct?
That's correct, Your Honor.
So now your complaint is you want the jury to know that a polygraph is not admissible.
I don't have a complaint, Your Honor. I believe that is in the pursuit of justice and fairness, the jury should be entitled to hear the law on polygraph examination. I'm not asking to tell them not to believe the document. They should hear the law on polygraph examination. That's it, Your Honor, because of the unredacted part of that confession.
All right. So that objection will be denied. Is there anything else from either side?
Nothing from the state, Your Honor.
All right.
So for the defense, Your Honor.
All right. So what we'll do is you each will have 15 minutes. I'm going to get the jury charge. And then I will give you all copies.
Thank you, Judge.
And does anyone want a time announcement?
If we can have a time announcement with 10 minutes left, Your Honor. Okay.
And who's doing the closing, both?
Yes.
And do you want a time announcement?
Just me, myself, and I, Your Honor.
No, I mean, do you want a time announcement?
2 minutes left.
Okay,
Thank you, Your Honor.
And Judge Vermeyen, can you let me know after 2 minutes has passed?
okay,
And I just open a trap door or something.
okay. All right. So,
Yeah, that's how I'm gonna first last.
all right, then they will have that. So if y'all remain, they will give you the information. All right, Deputy Laura, we're going to start our Q&A until noon. So the Zoom link for me to answer anybody's questions on matters unrelated before the court is 864-0133-629, 864-0133-62. Oh, I said 6289, didn't I?
Yes.
I'm sorry, it's 864-0133-6298, 864-01.
Address the fact that this is over 30 days and not lawful.
Denied. We started the hearing. I put Ms. Millard in place to do something so because I didn't want to bring this child in here and put
I
this child.
checked and you were incorrect. I was not served. I apologize. There is a delay. I don't know when I'm interrupting you.
Ask your next question, ma'am.
All right, I'll show you a video. Have you ever tried to kidnap Wyatt while he was at my house?
No.
Do you have a girlfriend?
I object to the relevance of girlfriend. Sure is.
Not relevant.
I'll show you a video and I'm going to ask you, you're in it. And it includes a woman who forced her way into my home and tried to, and explicitly stated that she wanted to see if you could, I'm going to see if you could recall this. You were pretty intoxicated. You might not.
Well, I'm going to object to the video unless it shows specifically, not just that he might have a girlfriend, but it shows the woman doing what she alleges she's doing.
Sorry.
Oh, we get to see the video and it does not show anything she purports that it shows.
What's the objection?
Judge, did you
What this video is going to show. Before you show it, tell me what this video is going to show.
It's about a 2-minute video. I've submitted it. You guys had it for about 3 weeks.
I do not look.
It shows a woman that that Shane lives with, and that said she was going to kill me, which backs up my claim.
No, it
And then Shane also agrees he's going to kill me in front of Wyatt while they try and take Wyatt. And then she breaks into my house, and I try to stop her. I'm wearing a heart monitor because I was suffering from COVID. And this is just one example of the things I live with all the time.
Well,
And
does the video demonstrate any of this, or does it just show that he has a girlfriend that may live with him?
it demonstrates it all.
What
And then there's
exactly
an email.
does this show him doing anything?
Yes, it shows him. And then it shows, I want to show an email where he describes what happened so that I can show you. I said that he has an alcohol problem. I can show you the difference between what his memory is of it and what actually transpired, which is stark. My life is threatened. If you're not interested in my life being threatened, I will say that 3 years ago, I was not able to get a restraining order against a stalker who pled guilty to 7 aggravated assaults.
Okay, stop.
And this ended up.
If this has nothing to do with this case, I don't want it. Just this case, please, this case. If you have a question for him, please ask it. If you have evidence that you're going to show something you need Mr. Shaw to see, send it to him so that he can look at it.
He's had it available for well over.
Do you have it? Do you know what she's talking about?
No,
He's seen it. My attorney sent it to him. He knows exactly. He doesn't want you to see it.
You don't have an attorney, and I've received no exhibits from you.
Yes, you.
I think Scott Shaw does a fantastic job throughout this whole circus of just staying calm. He's winning, and he should be. He knows what he's doing, and he just doesn't engage most of the time.
From Mark Shaw. Mark Lebacken. I also sent it to Marcy. Marcy, you've got it.
Marcy can maybe comment on it. I haven't seen it.
Marcy, do you have any idea what it is talking about?
I received a video like while we were in the hearing. I think I know what she's talking about. It appears to show dad's girlfriend, dad and dad's girlfriend on a porch.
I uploaded it. It's in the shared file.
I don't look
thought
at
we were
evidence.
allowed to do that. I'm sorry.
I don't look at evidence. Stop talking. I don't look at evidence until it's presented to the court. Please let Ms. Millard finish.
So it shows dad and girlfriend on what I
Objection. How do we know he's a girlfriend? It's a girlfriend.
Oh, dear God, you said she's a girlfriend.
I'm just saying how ridiculous it is.
I guess I'm not sure the purpose of it. It shows dad and girlfriend on what I assume to be mom's front porch based on the recording and things that mom is saying. Mom is taking the recording. There are children that are pictured in the video. I'm not sure.
Oh, you don't remember when she says, "I'm going to kill you," and I'm so rich, bitch. I'm so rich. I'm going to kill you. You don't remember that?
Then it was a different video.
Well, they play the video. You guys tell me. I don't hear anything like that. I don't hear anything insinuated like that. But you guys be the judge.
Oh, okay.
She may have uploaded a different one. The only one that I saw was that one. And like I said, it was coming during the hearing, so I may not have seen it.
Is that relevant to have someone?
Play it. I'll watch the video. Play it. Play it. Go ahead and play it.
I like Judge Manning. She's just like, I don't care. Now I'm curious. Play the damn video.
You know what? I'm taking him on on a vacation. I want you to get off my property right now.
You're not sharing your screen. All I see is you.
I want you off my property right now. You, why are you?
I don't see a video, ma'am. All I see is you. You're not sharing your screen.
Right light in my eyes.
Ma'am, you are not sharing your screen. All I see is you.
Excuse me, how do you share your screen?
There's a share screen down there at the bottom. I cannot give you Zoom, ma'am. I can't.
It says share screen. Now you can't see that.
It's sharing your screen.
It says it's sharing my screen now.
No, it wasn't. Go ahead. When was this taken? Give me some information. When was this taken?
This was taken a month and a half ago.
Who took the video?
I think I did. Yes, I did.
Go ahead.
Come on a vacation. I want you to get off my property right now. I've never met you. I want you off my property right now. Why are you smiling like a psychopath? Off my property. Right light in my eyes. You just came over and
Advocate.
out of the blue walked into our house, banging on my bedroom door. I didn't bang on it. I had it on. I had it.
By the way, Jen sent you a link.
I didn't come upstairs. So you didn't come upstairs. No, I didn't. What are you saying that? I walked upstairs. You told me not to stop upstairs. We want you off the property right now. 911 has been called. Good, call them. Let's go. That's not how property works. Everyone, we'll see right here in the segment. I don't remember. You just really call 911? Are you? Because why is this going on this trip with us? Because you've been neglecting him. What are you talking about? It's been 7 weeks since you talked to your child. Yeah, but she didn't talk to your child for 7 weeks. He's been very upset and crying to me about it. So tell me about it. Tell me. So he's been upset and crying? Yes. Tell me all about it. You think you know what's going on? You think you know what's going on? I don't care what's going on. I don't like bright light being shined in my eyes. Then get off the property. You're not supposed to be on here. Well, my children are in your house. Because you brought them in, you lunatic woman. Okay.
Well, listen to the projection. She keeps calling the other woman a lunatic who's sitting there acting calm as a cucumber.
Child. You need to go. Child. Do not call my child a child. Yes, she's being called a child. I'm glad that's on recording because that is crazy as shit. You are intoxicated. You are very clearly intoxicated. Oh, okay. That's fine. I can't wait. So I'm waiting for the police stop. We're gonna wait right after the gate for the police stop. And this is what you put your children through.
Miss Porter, I'm going to interrupt you. I didn't hear anybody threaten your life.
Here, you.
Yes, and they don't appear intoxicated either. I don't know. You guys tell me if I missed something, but they seem like rational people being attacked by a psycho.
You were talking in the middle of it?
Oh, I'm talking.
No, when you just said I'm going to interrupt you, that's what you said.
Okay, well, rewind and let me hear where she says I'm going to kill you. Just take it back. It don't need to go all the way, just a little bit then.
All right, put your earphones in.
I don't have headphones. I got a speaker. Just.
I got confirmation that it's very easily heard.
I don't know who gave you confirmation, but
You're saying you don't hear that woman say that she's going to kill me.
No, ma'am. I didn't. I don't hear. And she's not a party to this either way. But I don't hear him say anything. So where's he saying anything?
The point is, I'm going to ask him about an email to show you this is how he distorts situations. Now, I have had this transcribed. Had I known that this hearing was going to be illegal, I could have had an expert. He does. I will play it again, please.
Ma'am, I'm listening. I promise you, I am listening.
Okay, what did you just hear?
I didn't hear anything, ma'am. Go ahead.
Sorry.
Ask your next question. I didn't hear anything. Ask your next question.
What an absurdity. Okay. I'm going to ask, I'm going to get a piece of evidence.
You have another question for him? Go ahead.
I do. I'm looking for another piece of evidence. Remember the email?
I have no idea what email you're talking about, but you have a question for him while you're looking for that.
So who is that woman? Do you recognize her?
Yes.
Did you bring her to my home?
Okay, so it's kind of obvious that they walked there together and out together. Next question. I mean,
no, it wasn't obvious. She actually came over by herself. So I don't think it's obvious
okay.
at all. I think I'd
So
like
how
to
did he
recognize
get?
her.
Did he come up later?
Yeah.
Okay, so she
You
went on.
need to grab her.
Okay.
Are you aware that you have a restraining order where you're not allowed in my home?
I don't know what you're talking.
So in the final parenting plan, have you ever read a passage that said you're not allowed in my home? You're restrained from coming into my home.
I do not know what you're talking about.
All right. Do I need to? Can
do I need
counsel
to-
stipulate to that?
Do I need to show videos like how many times you come to my
Does
place?
counsel need to stipulate to that, or do I need to find the passage?
Do I need to show videos like how many times you have come to my house?
Stop
You live right next.
arguing. Stop arguing.
I've
Please.
asked a question. Will counsel stipulate to that there is an order? That restrains each other from entering the household of another.
So if there is, Mr. Shaw can answer it, but it's not called a protective order or a restraining order. It's language that's fairly common in a divorce.
It says both parties are restrained.
And that's typical in divorce cases. It's not a TPO like this.
I'm asking.
Mr. Shaw, is the typical, don't harass, is that in the?
Is it typical for people to come into their house and you seem to really want to make excuses for this guy?
I'm not making excuses.
Can I come to your house and act that way?
If she wants the court to
Shailesh, can I come to your house and act that way?
Ms. Porter, are you threatening the court?
I'm asking Shailesh.
No, answer me. Did you just say that to me? Are you threatening this court?
With what? I don't even understand the question.
You said, can I come to your house? Was that directed at this court?
No, I said,
Okay.
Shailesh said.
There is standard language that's in divorce.
Well, I appreciate that you see that as threatening. I appreciate that. I would like judicial
You just
notice
told me
that
you
that
were
was a
coming to
threatening
my
behavior.
house, Miss Porter, and you have no business here. That would be a threat to me. Ask your next question.
I'm sorry, what? I didn't hear you.
Ask your next question.
No, I apologize. I did not catch that.
Okay, ask your next question.
All right, so are you aware that you should not come into my home by order of the court?
Oh, it lasts
It does
forever.
not say that. It's just a common language that's being put in there.
So you believe that you are allowed to have entry into my home at will?
I'm going to object. She was on the porch like any person could come and knock on the door.
No, I will go back to the video and show you where he is in the video. This is absurd.
I saw him.
I cannot even get this man to.
Judicial notice, he was in the video. Next question, please.
Pardon? I didn't catch that.
Saw the video. He was in it. Next
No,
question.
he was in my home. He was in my home.
It appeared that they were all outside. I didn't see the inside of your house. Next question, please.
Well, then I will replay the video.
This was on your porch,
It was on my house.
outside on your porch.
No, he was inside my house. I will show the video again.
Wait, that was in your living room? What room in your house was that?
He was in
What?
my living room. 1 second, please.
Your Honor, I've been through the agreement and it just has the parties shall live separate and apart from one another and shall be free from interference, harassment, and molestation from the other.
So it is the standard divorce language.
Yeah, although she wants me to submit the J&D, it has detailed findings of her harassment and mental health issues in it. I would be happy to tender it as an exhibit.
I apologize. Did he just say that's my mental health?
I will let the J&D speak for itself.
Would you like for him to submit the order so the court can look at it?
I didn't understand the question.
Would you like for him to submit that order so that I can look at it?
For the purpose of that he's restrained from my house.
You want me to look at it?
Honestly, Judge, I feel like this is causing more conflict because I feel like you.
Ms.
I
Ford,
should be
you're
able to.
saying that there's something in the order that's restraining language.
No. Can you not agree that that was inappropriate and that was wrong and that was high conflict? And that I felt threatened. Why is he allowed to come into my home whenever he wishes?
Never too late.
Would you like for Mr. Shaw to submit a copy of the order so that I can read that order to see the language that's in there?
Yeah.
Yes?
Yes.
All right.
Okay, Mr. Shaw, if you email me a copy of the order
We should already
separately.
have it as Exhibit 10.
All right, do you mind emailing it? If
Okay.
it was submitted to Ms.
I
Spring.
also have it in my
Okay.
thing.
What is your direct email so I don't have to look it up?
Email it to Ms. Free. She'll email it to me.
I can email it to you. I have it.
Okay, there you go. Ms. Millard will email it to me. All right, so go ahead with your next question, Ms. Porter, while I get that so I can look at it. What's your next question, Brown?
All right, I'm going to show my screen again.
That's your desktop, ma'am. So just make sure you're sharing your screen. I don't want you to share something that you don't want to be sharing with the public. All right, so this is an email from, I see an email.
Mm-hmm. Yes. Can you recognize this email?
Okay, go back up to the top. Very top where it shows the addresses.
1 second. I gotta figure out how to move this.
Your Honor, I'm going to object. This is from March of 2022. I'm not certain what relevance it could have to the events that happened starting in July of 2022.
Right, so hold on, Ms. Porter. Just tell me why this email is relevant.
It goes to his credibility as to how we saw the video, and then this is how he describes it. Now, he has said he wasn't intoxicated. I said he was very intoxicated.
So hold on. So, Mr. Shaw, she's saying that this described that video.
The dates
You know that it does. Stop.
I don't know. Maybe it does.
Our attorneys have already litigated it. Stop it. You're ridiculous.
Ms. Porter, if you could please. Okay, go ahead.
Well, let her admit it.
I'm reading it, Mr. Shaw.
I'm better just being quiet here.
All right, I'm reading it. Okay. Now, hold on. Go down so I can see. This says Valerie. So this is him emailing you?
Yes.
Okay, hold on a second. Let me read. Okay. Okay. Okay, hold on 1 second. Don't leave it yet. Hold on 1 second. Okay, you can go. Is there more beyond my lawyer correct? Is there more beyond that sentence? Scroll down if there's more. All right. Okay, and then is that the end of it or is there more? Okay, I got it.
Okay. So has this? Do you recall this?
Yes.
Okay. Do you believe that accurately reflects the video?
We saw the video. There's nothing in the video. We just came to ask me. It was my
Just
parenting
answer
time.
yes or no.
Yes.
How good is our relationship, Shailesh? If, for example, how would you describe it? Would you describe we're on good terms?
No.
Have you ever invited me over to your home?
Well, now you got to do that in a time frame because ever,
Shailesh is my man. I love the response. No.
maybe, yeah. So you mean recently?
Ever?
Answer the question, yes or no.
No.
Have you ever asked Yuri and I? Now, you agree that Yuri? Do you agree that Yuri is my partner? We have 3 children together.
I do not know about 3 children together.
Do you know Yuri Vala? The one you spoke here?
Yes.
Your Honor, I'm objecting to the relevance of any
So
of
tell me how this person and that is relevant, please.
Because he says that, I'll read the email, okay?
But just tell me whether or not he knows that person is relevant, please, ma'am. Just answer my question.
Because I've asked about my relationship, and if Yuri's a man, I'm going to see if perhaps he has the same answer. If he is going to say, he said that he says here that he and Yuri are on very good terms. And I'm asking him if he is going to confirm that.
How is that relevant to this TP? I don't know. This is something that happened in March.
It goes to your credibility.
Sir, do you get along with whoever that person is? Yes or no?
Have you ever told him to go fuck off?
Okay, that's not relevant. Move on to something between you and him, ma'am.
Have you been vulgar together?
Ma'am, I don't care about whoever this person is.
Did you say Mr. Vala warmly welcome us? And that was you. Do you admit in here that you came into my home? Is that correct? You read those words.
We came into your home because he welcomed us. He was the one who
He
said,
warmed you.
come and ask
He
you
warmly
because-
welcomed you into my home.
Yes.
Next question.
What was the occasion that caused such a warm welcome?
Can we get back into like this TPO? Nothing in the past. This TPO, the events that led to this TPO.
The TPO is in the past. This is the same time frame.
No,
it's not.
it is not.
Please move on to the next question.
Do you still stand by that this is an accurate reflection of that video?
That's the email that he sent. I got it. I read it. I promise.
All right. Well, you slammed the door on us. Did that happen?
Ma'am, I've read the email. That's the email he sent.
I'm not allowed to ask him questions.
Are you going to ask him to confirm everything that it says that he wrote the email. Sir, did you write this email?
Yes, ma'am.
Okay. There you go. You don't have to ask him about that email.
I'm going to ask him then, did you hear me, as you say here, yell at a child, get out, kid, and then push that child out the front door? Is that what you...
Your Honor, it's not relevant whether she pushed a child or not in March of 2020.
It is relevant as to he is making accounts. He
hasn't alleged anything in that regard.
Just as he's recounting events here.
He hasn't alleged anything in that regard nor testified about anything in that regard.
I say it has to do with his credibility. He is explaining events that we have to take his word for. Here we actually have a video and how he describes it.
My objection is made.
And I want to know.
I have made notes about the email. I've got it.
I don't think you get it. I want to know if he actually remembers it. Remember, I said that he was
Hold on a second.
intoxicated.
Do you remember sending this email? Yes or no?
Yes, ma'am.
No,
Is this-
does he remember it this way?
He remembers it. He remembers it in cartoon figures, stick figures,
I have no
anime.
idea. Do you remember me pushing
No,
a
no,
child?
stop, Miss Porter. Stop. This horse is dead. You have beat it to death. I see the email. He wrote it. I've read it. Made notes about
That
it.
is absolutely not an issue. I am asking if he remembers.
You have. He remembers writing this email.
But was it true or not?
Oh, dear God.
I can't understand why y'all are behaving this way, as if it has
I'm
nothing to
behaving
do.
this way because I've got it. I've entered it into evidence. He wrote it. That's it. He wrote it. What are you going to make? He's going to write a lie? He wrote it. I'm taking it for that. He wrote this.
No, I want to
Ms.
know,
Porter, please ask the next question.
were you intoxicated that night?
No.
Was your friend intoxicated?
No.
No.
Had you been drinking at all?
No.
Had you been using any sort of drugs, prescription or otherwise, that would affect your cognition or memory?
No.
So how do you like that?
When you when you say that you're going to have me arrested for the child abuse that you claim you saw sober, was that a threat, or was that
No, I
a real
object.
threat that you felt you had to act upon?
The video had no such conversation in it.
Ma'am,
Yeah, the email does.
Ms. Porter, the video spoke for itself. I took notes. I didn't hear that. Ask the next question.
No, the email says he's going to press charges for child abuse.
I saw that. There you go. Next question.
So, are you aware that I've been speaking with Wyatt's social worker at his new school?
That is what you told me. So I have to go by your word. I'm not verified with her.
When did I tell you that?
You just mentioned in your text message. But she's not here, so I can't speak for her.
Well, I was not notified that there's already pending litigation that he's trying to litigate it twice. Do I have to pay to defend myself twice? I have an attorney for the other one.
Okay,
I
tell
would
you
have
what,
shown up without
I'll
evidence.
tell you what. Please move on to the next question. How would he know if you're talking to the
Well, I'm being punished because I didn't call her as a witness. She's called.
No, ma'am, you're not being punished for anything.
Is he really allowed? Or is he allowed to?
See what? Now what, ma'am?
No, I'm asking a question. I'm asking a question, please.
How would he know who you're talking to?
What I am asking you a question. This issue with the school is being litigated in a separate matter. Is that not correct, Mr. Shaw?
We filed a custody modification and that will be relevant in that proceeding, yes.
Is that not specifically noted as the basis?
No, there's multiple bases for the modification, including your mental health and well-being.
Is that, please answer the question yes or no. Is that noted as a basis?
It's a fact. It's an element of the claim.
That doesn't exhaust anyone? So it's an element of the claim. So I have to defend that claim here, and I have to defend that claim there. Yet no claim was shown to me that this was going to be litigated today. I am already waiting.
Ma'am, it's honestly not unless you're bringing it up. You've heard the allegations.
That was the only thing he talked about. That was the only thing he talked about. That was all the evidence.
Okay, do you have any more questions for him?
Yes, what is the basis for your claim here, Shailesh Manjunath? Why do you need a restraining order?
Answer the question, sir.
Yeah, because Every time I send my child, I did not get him back. And when the Florida incident happened, we took him out of state and withheld him for 10 days beyond your stipulated parenting time. And
There, do you like that answer?
also, like on the second incident, when it happened, you kept him, and despite knowing where his
The whole
school
basis
is,
of the
and
petition.
me sending you the details of the school, you did not take him to school for 5 days and kept him at home.
Ms. Porter, I believe you have also put in the last 3 that you're going to take him out, your child out of the country. And in the breakout room, Ms. Millard said that you said that something about you were going to leave with a child.
I said I have a humanitarian visa, and I expressed that that is legal.
Okay, stop. I got a couple questions for you. What? What's your humanitarian visa? What? Explain that.
I've sent you information.
The court does not look at anything ex parte. Explain to me your humanitarian visa.
All right. I've got 9 pages.
Here we go.
No, explain it to me. What's your humanitarian visa?
I don't know what that means.
What is it?
What do you mean? What is it?
Okay.
So when a country, for instance, I already have been recognized as a persecuted individual. So to my family, Wyatt, he has been recognized. I'm negotiating, and they have offered me a humanitarian visa because it has a narrative.
So who has done this? Tell me who has recognized.
That's confidential.
No, if you got, I'm asking you.
Are you kidding me? So the protection is from this court, and it's not from you. It's not from you. I think that.
Who is it that has given you some sort of protection? What country? I mean, what are you talking about?
I'm talking about Wyatt and my family.
Okay.
Getting a humanitarian visa.
From whom? That's right. Whom? There are several countries that
you understand. I understand where you're coming from, but if this county is already being represented in that court, so
wait a minute. Hold on. Wait a minute. Okay, explain that to me. I'm really trying to understand. This state is being represented in a what court?
It's complicated because of Brexit, so I technically have 2. I have obviously been offered asylum in Moscow. Only if it's necessary. I think that.
Okay. So you've been offered asylum in Russia. Yes or no?
I said I have also been offered asylum in Russia. The humanitarian visas are for my children. They are legal. They are legal. And Shane has had an opportunity to argue, and he has lost it.
Okay, hold on, I'm trying to figure out. So which court are you arguing this in? I guess
it's more of you would call it an administrative tribunal. You know exactly what humanitarian visa.
Ma'am, I'm asking you, Ms. Porter, because I'm trying to figure out what you're saying. Are you in front of an immigration judge?
No, I'm not. I was. So the district DA, Judge Whitaker.
Now, okay, hold on. Judge Whitaker is not a DA. That is a judge.
She's the deputy DA. She was.
She worked in the appellate.
I was sexually assaulted by a police officer and a man named Jackson Alley. Judge Whitaker framed the police officer for the assault. I was actually assaulted by both. Then I experienced a series of I will read it then. You asked about it, you're gonna get it.
I mean, I'm just.
Then Shane got with the rapist, Jackson Alley. He took a plea deal, and then he litigated it in front of Judge Whitaker. Judge Whitaker had already had to cover it up once. She was terrified to do it again.
What are you talking about? Cover it up. Explain that to me. I'm trying to.
She framed a police officer for my rape, and it wasn't him, but it was expedient. I will have to read it to you.
Okay, that's fine. So tell me what.
Can I present it?
What is it you're wanting to show?
You're asking me.
Are you wanting to show an order, a petition, an email? What is it you want to show?
You said, what's the basis?
Now, you said you want to show something. So what is it you want to show me? A text, an email?
It was an affidavit.
An affidavit. Okay, who's this affidavit from?
This is for me. I was trying to explain to the court what a humanitarian visa is.
Sure, go ahead, share it.
And I repeatedly say through this affidavit, which I had given Marcy.
Feel free, share it. Go ahead.
How do I share a document?
We get there.
So you got to take the screen down you're sharing and then share another one. Now you do another screen share. It's not sharing yet.
Okay, is there a way that I can deliver it to you?
Can you not? I mean, you shared your screen before. You can't share your screen.
All
So
right.
you have to pull it up and share your screen like you did before.
Mr. Manjana, do you know who Jackson Alley is?
It's not sharing yet, Miss Porter. I just see you.
Mm-hmm.
All right, how about you? Until you figure it out, how about you move on to the next question?
That was my next question.
Okay, go ahead. You know who that is, sir?
I just know from her telling me just now that.
Yes or no, and then you can offer an explanation. Do you know who he is? Yes or no?
Yes.
All right, next question.
Have you ever met him?
No.
You've never met Jackson?
No. Next question.
Have you ever called him as a witness in any of these custody litigations?
No.
Have you ever had your attorney seek him out?
Thank you. Happy birthday.
Have him be called as a witness?
I haven't asked my attorney to do that. If my attorney did that, I do not know. You need to tell me which specific attorney are you talking about.
Did you not submit hundreds of documents from Jackson Alley to the custody evaluator?
Your Honor, I'm going to object. There's no relevance. She's made the accusation that I don't even know who this Jackson Alley is, that Jackson Alley raped her. I called him as a witness to intimidate her. Now she's talking about a custody evaluation.
Yeah, I have no idea why you're acting like you don't have anything.
Okay, look, Ms. Porter, please stick to the issues at hand. This isn't a modification. This is just the very limited scope. Move on.
But we're going over the issue of the modification.
We're not talking about the modification. Okay, you're sharing this. Gotcha. Okay, scroll down just a tad.
Have you ever been called for any litigation regarding this?
No, you're talking about something that happened in 2008. I met you in 2014. So
that's a no. That's a no. Thank you. Next question.
No, civil litigation that the state is trying to settle with me. Regarding regarding your conduct in the custody and the mistake.
Okay, I skipped past that. That exhibit was her own affidavit, which is an affidavit is what a witness will say in court. She's in court. You don't need an affidavit, but it goes on for a half hour. The entire time the judge is trying to read it off the screen share and she won't shut up. I mean, it's pretty delicious, but it just takes too long.
Takes you induced.
I do not know what you're talking about.
Have you ever testified? Or given a statement, maybe not testified, but given a statement?
I just know that we went through a divorce trial and we filed custody modification last year. We again filed for a custody modification. So whatever you see on the Fulton County Superior Court, the case is open. That's all I'm aware of. And closed.
Next question for you, ma'am.
I'm asking for a continuance. I will bring someone from Chris Carr's office. I believe that this is a serious matter and it deserves serious attention. This was sprung on me. And
no ma'am. We had a new court date set at the last hearing when Miss Millard was appointed as the guardian, which by the way,
but I did not expect you to unlawfully extend it past the 30 days you are legally allowed.
Ma'am, you were served. There's an affidavit by there's a service affidavit filed by the sheriff's office. We started it. I am allowed to continue it once we've started the hearing. Move on beyond that. Do you have another question for him?
I repeatedly asked if I can have a continuance.
Denied. Do you have another question for him?
Why did he get one?
Y'all only got one so that Miss Millard could do something. Do you have another question for him, or do you need to tell me your side of the story, ma'am?
I'm asking you a question, a genuine question. Are you allowed to take judicial notice? You said that I was served August 8th? With what?
Would have been August 17th.
August 17th, ma'am.
With what?
The TPO, ma'am, the ex parte, the petition and the order. Do you have another question for him, or would you like to testify on your own behalf?
No, I'm asking you, what?
Ma'am, you don't get to ask me questions, but you were served on August the 17th.
Okay, is Ms. Marcy, is she appointed through the modification?
She's appointed through here and the modification. Do you have another question?
Yes, may I have a copy of the order? I haven't received it. That is my question. I haven't received it.
Ms. Millard, send her a copy of the order. Next question. Do you have another question for him?
Mhm.
You have another question for him? Because it's rolling into 5:07. So do you have another question for him, ma'am?
I'm trying to put it up.
Okay, no, ask him a question.
No, I'm trying to
ask him a question.
Okay, did you change? All right, so it seemed like your attorney made the admission that you moved without giving any notice.
Ma'am, I don't care. Take that up in front of the judge that's handling the modification, because I'm not handling that.
Then
Who's
what?
Miss Millard? Hold on.
What is?
Stop, Miss Millard. Who's handling the modification?
Judge Ellerby.
Have I been served in that?
I don't know. I'm not Judge Ellerby.
I'm asking Marcy.
Wicked skinny, and she has brown hair, not all this salt and pepper. We look completely different. You would never mistake me for, I'm mistaken for Judge Angela Duncan, but not her, not Judge Ellerby, that's for sure. So please ask your next question.
I believe I had a question on the floor.
That's about the modification and something in Judge Ellerby's courtroom. I would not, nobody on here can answer what's going on in Judge Ellerby's courtroom except Judge Ellerby.
Can someone, it was about.
Ma'am, I am begging.
No, please. Those text messages, I'm trying to ask him a question.
No, ma'am. I'm muting you because you keep talking over me. I have given you so much leeway. So much leeway. You're talking about stuff that is not relevant. Mr. Shaw, I don't know, has kept his mouth shut. And I've litigated against Mr. Shaw, and he stands up every time I used to open my mouth in court. He stands up, waves his arms, makes a big deal out of me talking. So I've litigated against him. I don't know. He has sat there quietly, which I'm really impressed with. I've litigated against Miss Millard, who used to jump up and down every time I opened my mouth too. They both made a huge deal. Like Alex Manning didn't know what she was talking about. Sometimes they were right, sometimes they were wrong. Now, I want you to stick to the issues at hand. Judge Ellerby can handle everything else. But Miss Porter, let me warn you. I'm really being patient here. Judge Ellerby is patient, but she likes you to get to the point. And you were on, what was the name of that? Anybody know the name of that Braves player that time that was late to the game because he couldn't figure out how to get off 285? A long time ago. Remember, he was like looping 285. I couldn't figure out how to get to Fulton County Stadium, which no longer exists. But you're on 285.
This puts me in mind of a Judge Maribel detour.
And you can't figure out how to get off. I need you on the connector. I never, ever, 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 ever get on 285. I stay on the connector straight up and down town. I need you back on the connector. Do you have another relevant question for Mr. Shaw's client? You're on mute. I muted you because you're talking over me. Take yourself off mute and tell me if you have a relevant question. Because if not, Miss Porter, I need to hear your side because we're not going all night.
Yes, my question I was in the middle of asking is, so have you asked for monetary damages in this TPO for pain and suffering?
No, there's no such thing. Next question.
I asked him if he asked for that.
I'm telling you, there is absolutely no such thing.
That doesn't answer my question.
I'm telling you, there's no such thing. So if he asked for it, he wasn't it. There is no such thing as pain and suffering.
So were the Florida texts about pain and suffering?
I don't care about what happens in Florida. I don't care. Please move on.
Were any of these texts that you showed today about anything other than Florida?
Answer the question.
Yes, it's more than Florida. There have been two instances. Second instance where you again.
No, I asked about the text that you showed.
Ma'am, just answering your question. Here's the thing we learn in law school. You ask a question, you may not like the answer. That's why we're taught in law school day one. Never ask a question you don't know the answer to. I've done it. I'm sure Mr. Shaw's done it if he'll admit it, and I bet Ms. Millard's done it.
Yep.
Yes.
Question
he said earlier that they were all in Florida.
Miss Porter, you're in Georgia. Please focus and ask him a relevant question. Please, I am begging you, Miss Porter, to ask him a relevant question.
Shailesh, were any of those texts about Florida?
All right, Your Honor, I'm just going to pipe up here. The text speak for themselves. Some were from Florida and some were from Georgia.
All right, that was not clear at all. They all appear to be from Florida.
I don't care. I've read it. I don't care if they were sent from.
In fact, you said they were in Florida.
Miss Porter, I don't care if they were sent from Moscow. Their text.
This is Georgia. Only talk about Georgia.
Miss Porter. Read them. I've considered them. Please move on to your next question. I don't care if he sent them from Zimbabwe.
But don't you see it's important for me to understand his argument? I don't even know what state he's talking about. Do you not agree?
Georgia. What's all I care about is Georgia. I'm not a lawyer in Florida. I'm not born in Florida. Stick to Georgia, stick to relevant, and move on. Please ask him your next question.
Are you being investigated by Florida police for calling in the human trafficking violation that got us stranded in Florida?
No.
Have you been questioned?
No.
Sorry, maybe I didn't phrase
it. Said no. Ask him the next question.
Yeah.
Let me be. I'm sure
he said no. Ask him the next question, please.
That wouldn't make any sense. You not. Then how would you have any information?
He said no.
Yes. My question is, then how would you have any information about Florida?
You're the one who wrote me an email saying that you're being investigated. You're the one who sent in a text message that the Florida CPS is investigating you.
Next question, ma'am.
No, I'm talking about
Is that the clarification you were looking for? Because it's fantastic.
the police.
You're the one who sent an email that the police are investigating you.
There you go, ma'am. There's that question.
The judge is losing her freaking mind, and rightfully so. It's too good.
You didn't know the answer to. Please ask the next question, Ms. Porter.
The police are investigating me for.
Ms. Porter, okay. Do you have another question for him? Because if you don't, you can
What is
testify.
the police investigating me for that you claim I told you?
The police. please ask him a question and then you can testify.
No, I am asking a question.
Ma'am, he's not the police. He cannot answer that question. Move on.
I am asking him.
He doesn't know why the police know why
He
they're.
claims that I told him. I am asking him what specifically I told him that made him come to that conclusion.
Go ahead, sir.
I don't understand what Florida has to do with the basis of the
Sir,
TPO.
stop. Sir, answer the question.
Yeah. So you are the one who told me you're being investigated by the Florida Sheriff Department as well as the CPS, and then we have tendered the evidence, the Osceola County Police report. So everything is in the.
I didn't see that. I apologize. Can I see that?
Your Honor, I object any such.
No, ma'am. Ask him the next question.
I can't see that evidence.
He said you told him or using that. Please, ma'am, ask him the next.
He said he tendered it. He said he tendered it.
Miss Porter, please ask him a relevant. You know what, Miss Porter? Tell me your side. Tell me what's going on. Tell me your side. I'm really. You've got me curious.
I'm not quite sure exactly what the underlining basis for the TPO is, to be very honest. Mr. Shaw said he was not scared. He said it's only about Wyatt missing school. That is what he said. And whether I'm allowed to record things or not, in your opinion, that is what he will be held accountable to. We're not making fiction here. So I'm trying to understand.
Oh yeah, we are.
What this basis is. What if I'm to defend myself, what am I defending myself against? He said it was school. So where should I put my time?
So Ms. Porter, let me fill you in. You were served a copy of the petition and the order. You read it. Respond to that. Go.
Okay. So the copy of the petition mentions nothing about school. So do I still have to address it?
Address what you'd like, ma'am. Go. Go. If you want to talk about him being in school, go. Go ahead. I'm listening. Go ahead.
Mr. Manjanat.
No. Testify. Go ahead. I want to hear your side of this.
My sentence begins with the words Mr. Manjanat.
Okay, go ahead.
Mr. Manjanat abruptly moved, and without telling me. This is well documented, and I expected that this claim already being filed and parallelly litigated in the same court had a different scheduled hearing. And I don't have that information.
Parallelly litigated. I mean, there's just too many shirts to make.
He, in the final court decree, he states that he gets the first week of school before school. That he exercised that for Grant Park neighborhood school. However, without telling me or Grant Park neighborhood school, he enrolled him and moved an hour away from me. And the school was not aware, and the nurse was not aware either. When Mr. Manjanat's new school, which is in Sandy Springs, when
none of this is relevant. Attorney Shaw knows it, but he's just given up on this hearing entirely and is letting her hang herself.
Wyatt's new school, it started a week after the Grant Park school. So he thought that he gets 2 weeks, even though Wyatt didn't go to the Grant Park school. So he's done this before. I didn't get any notice that he moved. And the school, the counselor who is a social worker,
right,
Mr. Manjanat, shared the TPO. I did not know about it. And she asked me to stay at home because it was a complicated situation and she didn't know what to do. And I didn't know what to do. Mr. Shaw has been sanctioned before for having papers delivered to Shane's address and then claimed they were served there. That was actually the last modification. He has been told time and time again, it's pending appeal. You cannot file a modification. He is awaiting to see if the judge is going to award him more sanctions for filing that appeal when there's no clear jurisdiction. There will be no modification. That's what I was trying to explain when I was talking to Marcy. He has been told this is the third time he's tried to file modifications. There, it is still pending appeal. That has to do with the pending litigation that you were seeing on the first trial, which is being investigated. And I am trying to negotiate an ending to that. And just everyone wants an ending to that. And that's it. You know, I deserve restitution. Judge Whitaker has acknowledged she should have recused herself. The judgment is going to be voided. I mean, it's acknowledged confidentially. I shouldn't have said that. I forgot this is public. As part of negotiations. I mean, some of this I can't talk about, but she should have, it's going to be void. And Sean knows it. He's been given a heads up. Shane certainly knows it. And the orders, I have gotten, I think it's 10 emergency custody orders in TPOs in the last 2 years. He's won none of them, but it's deprived me of my son.
I understand you.
Oh, okay. Oh, you can interrupt already. Am I testifying?
I'm making an objection, and that we have to listen to a narrative, that's fine, but none of this is relevant to a TPO proceeding.
Yep.
Porter, how is this relevant?
Which part? Because as he said, I spent for a long time. Is it not relevant that the school that he served the school and then the school told me that the paperwork they have says I'm not allowed on their property? Is that relevant?
No.
That is not.
It is not relevant. No, it is not relevant, ma'am. If the school has a TPO, they're merely enforcing it. Next.
Yes, but by telling me not to bring Wyatt to school, is that relevant? Am I not being accused of withholding Wyatt from school? I could have sworn I was.
So get to that, ma'am. Keep going. Go ahead. It's 5:23, ma'am.
Get to that. That's what I said. Mr. Manjanot has stated on the protective order, the temporary protective order, incorrectly that he lives at 756 Ormwood Avenue. He doesn't. That shows that he has lied about his address to me in order.
Don't care about that. Take that up in the modification.
What? Please, can I finish? In order for him to make me believe that Wyatt still goes to the Grant Park School. Instead, he moved him an hour away. The first day, I was told on Wyatt's first day that I had to take him to school an hour away.
At this point, I'm objecting to the hearsay. I've let it in, but at this point,
I can't.
Mr. Montanot's here. It's not hearsay.
No, you're trying to tell me what the counselor said. Can't hear it.
No. I am saying what Mr. Montanot said.
Were you there?
He was speaking to me.
No, I wasn't there.
Mr. Manjanot did not tell me that Wyatt had moved and changed schools an hour away into the very day that he was to attend. And if it is hearsay, and this is not an issue that it was originally brought up, and in fact, at the last conference, he said that he was not going to bring this up. And if you call it a hearing, well, then my goodness, that's on the record.
Ms. Porter,
he was not going to bring it up, and he was saving that for the modification.
Talk about things that
I should be able
day. I have been listening to you. I just want you to respond to the allegations. Once you've responded, move to the next thing. Please, Ms. Porter.
So the allegations are that, so as far as the Georgia thing, it's my understanding that that was him believing that he could take the 2 weeks. Do you understand that? So you have to.
Smarter than I sound, Miss Porter. I can promise you, I'm smarter than I sound.
I didn't understand that.
I am smarter than I sound. I promise you, and smarter than I look.
I'm speaking about the final order. Do you have that?
Me if I understand something. Yes, ma'am, I do. I passed law school and the bar.
She is a hoot. I mean, she is out there.
She's incredible. I've loved everything that she's been saying.
Yeah, she even does that. Like you were mentioning it, and it's true. She's let tons of stuff go, but she decided to do that, to let this woman say whatever she wanted to say. I think because she knew where she was going with the ruling.
It's incredible to me. That actually is a skill of being a judge, is knowing when to let the litigant just give them enough rope to hang themselves.
Yep. But she is cracking me up here.
I can read. I get it. Please, please, please.
I'm not sure how that has to do with me being an effective.
You're just asking me to understand something.
Yes, that I said. I'm asking about if I'm being effective. Am I being smart? Please don't take it personally.
The answer is no.
Am I effectively communicating it to you? That's all I wanted to know.
Is there anything
I'll just keep talking and talking and talking and talking. I mean, I don't know. I can't win with you.
Ma'am, this has nothing to do with winning. This has something to do with stating your case, him stating his case, and then it's the end of the case. So is there anything else you would like to tell me?
So in the final order, it says that he gets it the week before. He gets Wyatt the week before school. Because he withheld his address and that he had moved and then wouldn't be eligible for ANCS. And he was in Sandy Springs. He still took that week. So that was a week he withheld from me. Then the next week, he withheld Wyatt again because the school started a week after each other. And then he said he doesn't go here. And then he told me a different school that Wyatt went to.
Thank you, Kathy.
Right.
So if this is litigated here, will it have to be litigated in the modification?
I can't tell you what Judge Eloise wants to hear. Judge Eloise is going to want to hear what she wants to hear. But right now,
I have I'll address the Florida accusations. I'm unclear. You know.
Hold on a second. You know, you remind me of. I don't know if you ever heard this guy, Steve Shoemaker, likes to go up on these tangents that aren't relevant. He likes to go up on these Colorado tangents. I'm like, Mr. Shoemaker, I'm not a judge in Colorado. I'm a judge in Georgia. So, listen, all right? You kept the child.
His application for TPO is all about Florida. Do I have to address them?
I tell you what, Ms. Porter, do me a favor. Tell me about this thing. Here, let me bring you about something that concerns me more than anything I've heard today. Is this statement you made when you, Mr. Shaw, Ms. Millard, were in the breakout room? Address that.
Do you have the chat records from the last?
Well, once I delete it, once the hearing's over, it's deleted, it's gone. Tell me what you,
I said what I've consistently said to you and filed in court is that I have a humanitarian visa. Ms. Millard, it reflects very poorly on her, and I'm afraid that she's.
I'm guessing it's TPO's temporary protective order. What they're seeking here, because I keep getting the question. It's hard to see the forest for the trees. What the husband is seeking here, the ex-husband is seeking a protective order so that she isn't around the children for obvious reasons. But the behavior she's displaying here today.
And I are not going to work very well together.
Right.
She's blatantly lying. You cannot get asylum unless you are in that country. That is actually impossible.
But ma'am, you said you had asylum in Russia, and right now, American citizens are allowed to travel to Russia.
That's you're yes, I'm talking about Wyatt. I have citizenship because of the EU.
You have citizenship. Where do you have dual citizenship? Russia?
No, but Yuri does. But
Where?
I
didn't hear you. Where's your dual citizenship?
So you're telling the court that you're going to take the child out of the country.
Yes, she's testified
That's
that Yuri's her boyfriend. He's got Russian citizenship, and she's so out there that she's suggesting to the judge, like, well, I don't have Russian citizenship, but my boyfriend does, so he can get us in. And the whole allegation is that we're afraid you're going to take this child to Russia.
That's the opposite of an argument. That literally is just admitting the arguments.
It really is.
When in England and Ireland, so that's technically the EU.
Okay.
And I'm negotiating between both countries. When we came here,
hold on. I got a question. You have triple citizenship. You're a citizen in England, Ireland, and the United States.
No, it wasn't. You understand what Brexit is, right?
I knew those limeys were involved somehow.
Yeah, they always are. As an Irishman, and Brian kind of gave away the tale.
Yes, I'm sure none of these places have anything to do with it. Nothing whatsoever.
Are you a citizen in England, Ireland, and the United States?
I require no visa for any country in the EU or England.
Oh, you need a fez now.
We're refugees from Northern Ireland. It's a complicated legal fiction.
It's not that complicated, ma'am. You just don't believe I'm smarter than I sound. Anything else that's relevant to this TPO?
I don't see how that's relevant to the TPO.
Well, you're the one telling me you have triple citizenship.
No, I did not. I absolutely did not. I said I don't require a visa and I have citizen rights. I have been asked to move my dual citizenship to England. I'm in the process of that. So I basically don't have an answer exactly where I'm in the process of it. That's neither here nor there. I don't really understand how that's relevant.
Because you're going to steal the children.
Yes, and you keep running your mouth about it in open court.
Look at Scott right now.
Certainly something that...
Ma'am, you're the one that told me you had asylum and you were going to Moscow.
Jesus Christ. I did not say that. I denied it. How many times can I deny something?
Anything else is relevant, ma'am?
Do you understand? I have denied it. What I have said is, if I were to say to Marcy, I have asylum, that would be a threat, like I'm going to Moscow. Do you understand?
Yes, ma'am, I do. Thank you. Anything else you need to tell me?
A humanitarian visa is legal, and the United States would allow it. It is therefore not kidnapping. That's improper. Very improper that was phrased that way. And I think I've been accused of several felonies without evidence.
Well, more horrible argument. Yes, I do intend to take this child to another country, but I object to the characterization of what I'm going to do as kidnapping.
That is kind of the definition. If you look in any law book,
right.
Taking a child from a parent without any authority,
right?
That is kidnapping.
And it's exactly what the judge has to decide after all this. By the way, I cut this down. I know it's long. I cut like a good hour out of it.
Anything else that you want to tell me?
Yes, you've asked me to defend the TPO, but I feel like there's conflicting information as far as all of those text messages are from Florida, or supposedly about Florida.
All right. Mr. Shaw, do you have any questions?
I just, she's violated the TPO since it's been in place? I'll ask her about that quickly. Have you not contacted the closing attorney for Mr. Manginet's new home and filed a lis pendens against it, claiming there's still a divorce action open?
She filed a lis pendens.
The only lis
against the
pendens
house?
I'm aware of.
Yeah, I think she's soft sit and all this stuff. I haven't focused on that, but I think she's doing a lot of soft sit things on the side here. And I'm sure, I think she just filed a bogus lis pendens to screw up his, to screw up the transfer of that property.
Oh my God.
Of course, she
And
denies it right here.
He's been so reasonable and so polite the entire time, and I want to give him credit with all of the personal attacks she's been bringing against him. Him maintaining composure is really respectable.
Yeah, it really is. And that's the thing. You'll see she sort of denies this right here, but there's nobody who's watched this that doesn't think, oh yeah, Attorney Shaw has the goods on that, and he's not asking out of the sky. That she did this, but she won't admit to it.
I was going to say, if it's in Florida, I can pull the lis pendens. That's not that hard.
In the divorce is from February of 2 years ago.
Did you not contact the closing attorneys that are working on the sale or the purchase of Mr. Manginet's home?
I did not, and I would not know.
I don't know for sure, but I almost guarantee that Scott Shaw has spoken to those attorneys and knows damn well that the answer to that question is yes.
You wouldn't ask that question if you didn't.
Yep.
Okay, then let me ask you this. Did not your boyfriend, what is his name again? What is your boyfriend's name again?
Yuri?
Yuri. Did you not send him to talk with the buyers of my client's home to tell them that he has a criminal record and that they'll be in trouble?
Absolutely not. That is absurd. You are ridiculous.
All right, and did you not claim that Mr. Manginet threatened your life by phone today or yesterday?
Yes, he did.
Do you have a record of
No, I did not. I said he threatened to kill Wyatt.
Oh, now it was threatening to kill Wyatt now is the story.
That's what I said.
Hey, now we got information. Let's do it.
All right. Ms. Millard, do you have any questions?
I don't have any questions, but I would ask the court to address the payments of my retainer since Ms. Porter has not paid anything yet.
All right.
Ms.
Porter, when do you intend on paying Ms.
You guarantee what?
That guy did not threaten to kill his kid.
Oh yeah, absolutely.
So now we've got defamation in open court.
Yeah, and this, it carries on, but watch her evade the question of whether or not she's going to pay Marcy Millard.
Millard, because not only am I addressing it, but Judge Ellerby's going to address it.
Okay, I don't think I've been served with this Ellerby thing, and everything that you're telling me, I don't know anything about. I just don't. Have I been served with an order? I don't see in your case that any order was released, so I have not been served. I literally have not gotten it. Can you at least understand that?
Okay.
The modification I have not been served with.
All right. So, Ms. Millard has sent you a copy of the order. When do you intend on paying your portion of the guardian fees, ma'am?
So she is a guardian.
I will likely file. I have an attorney. This is for the other case. So this is that correct?
No, she's.
Yeah, she's the guardian, and oh God, and she's got an attorney. They go through this whole thing. You'll see. It'll make you pull your hair out even worse. But the attorney, if she has one, does not have an appearance entered on this matter. It's as simple as that. But they dance about it for 5 minutes.
Then it's irrelevant.
Yeah. I mean, it's set for hearing today on a continuation of a hearing. This isn't like a sneak attack or something.
Here, because I didn't want to bring the child in here and in the modification. So that way she doesn't have, do double work. She's done it. She'll report to Judge Elby. When do you plan on paying her?
I don't.
Right. Then we can all move on.
I'll likely appeal this.
Oh,
I'll
yeah.
likely appeal it. I'll have my attorney. I'm just getting this order. I haven't read it. I think that that's reasonable. What is she owed? I haven't gotten a bill. I don't understand.
There's an initial retainer. When?
What is it? How much is it? You know, no one has contacted me. I've not been, you just gave me an order.
Your Honor,
Generally,
she was served
imagine
via
about
Odyssey
$5,000.
on 9/2 at 3:21 p.m. She's a service contact.
Hey,
Yeah, don't you hate it when the guardian has the date and time? She of course has it. She in fact she had responded to it, which you find out later. So she's just lying and she catches
my God.
herself.
I mean, I know the Guardian has it up on her computer right now, the actual affidavit of service, and she's like,
Right.
"Hey, here you go."
Yeah, no one's buying it, but here we are.
Okay,
so when you're in, you get an email every time something's filed. So you were served with it because it shows in Odyssey that you received it.
I didn't see it. I'll have to, I checked Odyssey.
When something comes to you, you gotta open it.
Of course I open it.
Okay, well, it was sent to you. Is there, what's her half of the retainer, Ms. Malone?
$1,750.
All right, it's $1,750. When do you expect to pay Ms. Malone?
I'll ask my attorney.
Is your attorney gonna pay Ms. Malone?
He legally can't.
Brad McDonald is my attorney, and I am quite sure that he's okay with me asking him questions as to give you a legal answer on what can I not get advice from my attorney? Am I not allowed to do that? I mean, if I'm represented, but not here, is it fair or not fair that
Yeah, for the purposes of this hearing, you don't have an attorney. I don't care what you say.
this is supposedly has to do with two cases that you're asking me questions without my attorney?
Okay, I'm not sure I'm following that.
Me neither.
This is almost like following Mr. O'Hagan.
I have not been served. I have not been served with the modification.
Okay, so stand by. Okay. Ooh, like Mr. O'Hagan gets banned from social media every time he opens his mouth. So stand by. Have you retained Mr. McDonald? Is he on a retainer for anything?
Yes.
What's he on a
currently
retainer?
represents me against the last modification that Mr. Shaw still has open.
Be very
Okay, so
careful.
the
That's
modification
a first
now.
No,
Have you
there's
given-
two.
Yeah.
There's two. Shaw has filed two.
Okay, so this one that's filed now, that starts with a 22. Have you given Mr. McDonald money for this case, that case?
I have not been served with that case.
No, that's not my question is, have you given Mr. McDonald money?
Liar.
How can I give him money if I haven't been served?
Ms. Porter, you said he represents you. I
Yes,
know.
in the modification case. Please, we have two modification cases. Open.
How do you have two modification cases?
And he represents me. You ask.
Yeah, I don't believe it, but that doesn't make
One
sense.
is
I think
collateral estoppel against the other.
right. I think I'm not even sure because she says that the other modification case is closed. I don't know about the procedural posture, but I think if anything, you have a modification case with something going on and you have this TPO and they're separate actions. The end.
No, those are absolutely separate. You're not
Actually, do I have
represented in this matter.
Yeah. It's plain and simple.
I'm on retainer. Yes.
Why is Mr. McDonald here today?
Well, he told me that you're not supposed to. We've argued this. This is the third time.
Yep.
That we've argued this in front of you.
Mr. McDonald told you I wasn't supposed to do something?
Mr. McDonald argued this with you a few months ago, the same issue. You're not allowed to hear it.
Wow. Thank you, Mr. McDonald. Okay, first of all,
Do you want me to read the order that you signed?
would you
Mr. McDonald, if he exists, when he sees this, is going to say, I didn't say any of this. I didn't say one of these things she said I said.
I mean, it sounds like a great bar complaint. I
This
feel
is,
bad for Mr. McDonald if he does exist.
I was saying this at the beginning. I mean, I've been practicing over 25 years. I've been doing dumb court appearances on my channel for about 3 years now. This is literally the worst court appearance I've ever seen.
This is a disaster because she's trying to throw a lawyer that may or may not exist under the bus on top of her stupidity.
Yep.
Like for me to tell you, since January 2018, I have touched over 12,000 cases for domestic violence. So if I don't remember Mr. McDonald or you in a previous case, that's actually good. Because I don't carry any prejudices from former cases. So, have you hired Mr. McDonald and have you actively retained him in anything? Because everything that I see on Odyssey, which is the case, which is the software for Fulton County, everything with the exception of this and the modifications filed in front of Judge Earlby is closed.
No, so he's filed a motion inside that closed case to have it set aside and have the other motion. Look, just look in it. It's his response brief, okay? He put it in a response brief. So they're going to be merged. So he's just created a legal tangle. He's trying to pretend like he doesn't know that it's a strange, convoluted thing. If you look in his reply brief, he has asked actually for the judgment given in that modification to be set aside. That hasn't been heard. Brad McDonald represents me in that. Now,
do you have anything else that's relevant to this TPO to say?
Yes, I object. This should have been heard in 30 days, as you previously ruled, and is Georgia law.
And it was heard. Next, what else?
When was it heard? I don't understand.
It was heard, and it was continued. Next, Ms. Porter. Keep going. What else?
1 second.
What are you reading, Ms. Porter? If somebody is texting you,
I'm reading something from Mr. McDonald. Can you please? No one expected you to be acting this way.
That's a lie.
Mr. McDonald is texting you right now and telling you what to say.
No, I didn't
No
say he was
notice of
texting
appearance.
me. I'm going back to an email.
I don't care about an old case. I don't care about Mr. McDonald.
It's not about an
bless
old
this judge.
case.
I don't care
about what are you? I don't say these things.
In this case right now,
Lord,
is there anything else that you need to say about this case? Leave Mr. McDonald out of it. Leave O'Hagan, Shoemaker. Who else?
You accused me of texting someone. I am explaining.
She's dragging all the local firms into this now for no good reason.
This is a great way to get blacklisted in a community. I mean, I
Uh-huh.
don't know how big that community is, but
Well, this is
they
Atlanta,
talk with
Georgia.
each other.
It's a big one.
And okay, that's a big one.
But yeah,
they talk to each other, and you know, when I was
Yeah,
in
if
New
you're
York,
if you're
we would
practicing family law in
blacklist
Atlanta,
attorneys.
you don't want to take on this representation. Mm-mm.
That's what I was saying. Is like when I was in New York, and we would blacklist attorneys that treated our people badly, and everybody would know about it.
Mm-hmm.
Tell me if there's anything else that you need to say regarding this specific case.
I've asked for a moment to read an email. May I have that?
You got 1 minute, Miss Porter. That's it. 1 minute, and I'm rolling.
I would like to ask the court if the TPO is regarding Wyatt and Shane.
It's only about Wyatt. in itself.
Is Shalish Manjanati, is he being dropped?
It's about the child. It's on behalf of the child. All right, Ms. Porter, anything else?
1 second. I did file a response. I just don't see it online.
A response to what?
She filed a response. She is now saying to something that she claims she has never seen before.
That's a little challenging.
What now?
An answer to the
To
motion.
the TPO?
Mm-hmm.
We are going to
Nope.
get a ruling.
There's not one file. I don't think. Hold on a second. Hold on a second. It's pulling out. What? Okay, so tell me what your point is. Anything else you want to tell me?
What was pulling up? I didn't understand that.
Anything else you would like to tell me?
1 second. Let me check.
There is nothing else that you filed. Anything else you'd like to tell me?
Can I complete what I was saying about the human trafficking? Am I being accused of harming the children?
Ms. Porter.
In this
You were
case,
served a-
probably
Then I
not.
I need a
Porter.
defense.
Ms. Porter. You were served a copy of the TPO. You've had a chance to read it. You've had an opportunity to speak with Ms. Millard, which you were supposed to pay her. You didn't. You will pay her within 15 days. You neglected to do both. You've called Ms. Millard a liar.
Mm-hmm.
Whatever you said about Mr. Shaw, liar, whatever, you said bad things about Mr. Shaw.
Mm-hmm.
You probably said bad things about me because when I said I'm taking a break, you kept chatting, you kept screaming and arguing with Mr. Shaw.
Sorry?
So is there, I guess that didn't happen. Is there anything else that's relevant that you would like to tell me? In closing, go. You got 3 minutes. It's 5:47, and there's nothing that requires me to go beyond 5 o'clock. Go. Anything else? You got 3 minutes. Go.
Well, the only thing that is on the TPO is speaking about Florida. I'm going to take your word for it. You say that Florida is not relevant. Of course, I deny, and there's been no evidence. Said no one has actually accused me of harming Wyatt, presented injuries, said that I harmed Wyatt. And I think that I'm not sure. Mr. Shaw said 3 times before this court that I pose no risk to Wyatt and you're not worried about his welfare. I got it recorded. You're gonna be accountable for it.
Who, me?
Yeah. You gotta hear the things that happen.
Gotcha. I've heard it. I know what I'm doing. I've listened. I've paid attention. I'm taking notes. Thank you. Mr. Shaw, anything. 30 seconds, Mr. Shaw.
Yeah, we made her case. She committed the felony of interstate custody interference.
I'm sorry, I object. There's been no case about.
Thank you.
It's argumentation. You don't object to argument.
Anything you want to say, Ms. Millard?
No, Your Honor.
All right. I am putting this in place for 12 months, ma'am. I'm asking that you do a psych eval and that you follow all recommendations. You're also going to take the FBIP class, Family Violence Intervention Program. You will comply with my orders. You will take that psych eval. A copy of this order is going to be sent to Judge Ellerby. Ms. Millard, make sure Judge Ellerby gets this. You will take the psych eval and follow recommendations. You will be given a compliance hearing, ma'am, and you will show up. Because when you're not complying, every time you do, I can have a hearing on contempt and you can be incarcerated. Ma'am, you've got to pull yourself together for this poor little boy. This little boy is what matters. Miss Millard doesn't matter. You don't matter. Dad doesn't matter. Mr. Shaw doesn't matter. I don't even matter. This little boy is what I'm worried about. And ma'am, you are all over the place. The court's going to get a copy of this psych eval. I'm actually going to pass on that psych eval to Miss Millard and the Judge Ellerby's chambers so that she can look at it in this modification. And ma'am, feel free. Tell Brad McDonald to email court. If you've retained him in that case, I'll send it to him. I'll send it to Mick Hill. I'll send it to Meriwether and Thorpe. I'll send it to anybody you want to. But let me warn you one thing, Miss Porter.
You send what email? Sorry.
I have put up with your disrespect for this court for probably 3 hours now. 3 hours I've put up with this, ma'am. Don't put up with this. Ever. At my house, I'm not the boss. My spouse is the boss. And I can't do what I want. I gotta ask permission. But here, in this courtroom, I'm in charge. If you ever speak to me like you spoke to me before, not follow my orders, I'm gonna bring you into the courthouse for a love hearing. And one of the penalties is that we're gonna hear contempt. You can pay a fine. You can be incarcerated. Ma'am, pull yourself together. You may not respect me, and I don't care. You don't have to respect me personally. You will respect this position that I have earned. No matter what anybody thinks, I've earned this spot. I've been doing things since January the 1st, 2018. 12,000 of them I've touched, ma'am. 12,000. You will never speak to me in this position that I'm holding as you've done today. I would give this speech to him. I would give it to Mr. Shaw. I would give it to Miss Millard. Anybody else who was on here. Don't you ever speak to this bench the way you've done. And I will warn you, you call Mr. McDonald. Do not speak to Judge Ellerby like this or any other judge. I don't know what's wrong with people today. No idea. But this, you're going to show some respect. I've earned it. Maybe not in your eyes, but I promise you I've earned it. And the only thing I care about right this minute in this case is this little boy. That's all I care about. Not you, not him, not Sean, not Millard, not anybody else. Because right now, ma'am, if we were live in my courtroom, I would have put you in jail 2 hours ago by the way you're talking to me.
Yep.
But you know what?
Send the marshals.
I have held on to my patience. There'd probably be some people that are impressed with the fact that I've held on to my patience because I have, because I wanted you to be heard. You've been heard, ma'am. I read your affidavit. I've considered your evidence. I've listened to your testimony. I've watched your videos. Pull yourself together, ma'am. This is going to be put in place for 12 months. You are to have absolutely zero contact with that child. I will leave this in the hands of Judge Ellerby. If Judge Ellerby wants to modify this, Judge Ellerby can. Ms. Porter, I suggest you cooperate with Ms. Millard. Pay her. You got 15 days to pay her retainer. Ma'am. You think I'm playing?
A minute to take a break.
Try me. Because the most important thing right now is this child. That's it. This child. This child is all that matters to me.
That's all family law.
This child is going to be safe. Not going to be taken to Russia or anywhere else. Believe it or not, Miss Free left for the evening. I'm not sure why she did, but she did. So, Mr. Shaw, Ms. Shaw, do you want to draft it? Do you want to wait so Miss Free can draft it? Do you have a word of the order? I can send it to Miss Free, and maybe
I'll draft it. I also just want to include that she won't. But it should be part of it just to make clear she's not to contact any business associates and such, like with the house issue that came up as well.
Absolutely. And reserve attorney's fees, I guess, for Judge Ellerby.
I object. I'm sorry if we have business together and if it's about a Liz pendant from February 2019 or business
file.
Associates. I don't understand.
Yeah, she just contradicted herself right there, didn't she?
She did file a list pendants.
Yeah, she wasn't answering the question straight, but then she objects. She objects post ruling, which you can't do, and then makes another bad admission.
I certainly can.
You're going to get an order. I'm putting this in place for 12 months.
That's
Mr.
conversion.
Shaw,
I'm
why don't
sorry.
you put, they're there to communicate through our family wizard and to give Ms. Millard.
Can I ask for the basis of this?
I have found by proponents of the evidence that family violence has happened in the past, and there's a reasonable likelihood that it's going to happen in the future. Ms. Millard, so Mr. Shaw, if you put on there that they're going to communicate through our family wizard, and Ms. Millard will have access to all of that.
All right.
But
Are
there
we
was
doing a
no evidence
compliance hearing?
presented of violence.
What?
3 people talking at the same time. Are we doing
There
a,
was no evidence presented of violence.
There was a.
are we doing a compliance hearing? You mentioned something about that.
I tell you what, if he does that, I will get,
Kicked out, so if the audience.
Ms. Free to send out a date for compliance.
Okay.
So I'll get her to send out one to make sure that you've been paid, one, and that whoever else you hire, Kresge, Sheila Edwin, I don't know, Meriwether and Thorpe, who else, Stern, Montgomery, you name it, ma'am. Brad McDonald, I urge you to hire Brad McDonald.
I have hired him. You just saw that I did. He's been my attorney for several years.
This one, I urge you to do that. And that will be the order of this court. Mr. Shaw, send it to me.
I will do so. Also a question, is the recording available for me to obtain a copy of it?
That'll be the order of the court. Anything else? Thank you, Mr. Shaw. Email it to me. Mr. Shaw, I'll have to email it back to you so that you, well, okay, I'll copy Ms. Free and then you respond if you're going to e-file it or you want Ms. Free to e-file. I know she's probably on her way home.
Okay, yeah, that'll be fine. I'll be working this weekend. I got to catch up anyways and things. So
All right, thanks. This TPO remains in place, Mr. Shaw. If you have to do something down and dirty to get it to me so that I can sign it, please make this a priority so that this can be entered in GCIC. Ms. Porter, you are not to contact that child. Period. Thank you. That's the order of the court. Everybody can leave.
Thanks, Ron.
She's amazing.
Well, thank you. She is a hoot. That thing, I don't know. I think this is one of my longest streams ever. Well, no, because I get into trials. No, they've been longer. But I've done I don't know, probably 700 videos on this channel. Probably 500 of them involving horrible court appearances. This was the worst.
This was an absolute, unmitigated disaster.
What's up, court nerds? Welcome back to Time Served, the channel that scans the daily dockets so you don't have to. And I found an absolute gem at a Judge Lisa Martin's courtroom today. Our defendant, Mr. Daryl Morrissey, is moving around, smoking cigarettes, drinking, kissing his girlfriend, just being a dope on Zoom. And just about when he's about to be called, the popo comes a knocking at the door. A fight ensues. The judge gets involved. The lawyers are screaming. And all this is a wonderful clip for us to enjoy. Don't forget to hit that like and subscribe, set your notifications to all, and never miss these gem premieres. I'm your boy Phil. You have been served. Let's go to the videotape.
5 days to pay the balance, apply the bond. Anything else in this matter, Mr. Fufi?
No, Your Honor, thank you.
Anything else, Ms. Gordon?
Just to clarify, you said, is it $200 or $50?
It's $200. There's a $150 bond already on the file. We will apply the bond Oh, you know what? There's actually a bond on both sides. So we'll apply the bond. We'll apply the bond on both files and return the balance to you.
Okay.
Okay? I'll fix that. Thank you so very much, Ms. Gordon. You have a good day. Good luck to you.
Okay, thank you.
Thank you. Did Mr. Mexicot come out? No. This is 230517FY. This is, nope. Let's try again. This is 230490SM. This is the state of Michigan versus Jacob Bordeaux. May I state your name, sir?
Jacob Bordeaux, Your Honor.
Thank you.
Sanford Plotkin, appearance counsel with Jacob Bordeaux, who's waived his rights to be in person in court and proceed via Zoom, Your Honor.
Thank you. Ms. Shafufi, this matter is not scheduled until 9:45. Mr. Plotkin logged on early and indicated that he'd be requesting an adjournment of this matter, at least wanted to get the arraignment part done so Mr. Bordeaux can get on with his day. For purposes of arraignment, Mr. Plotkin.
Stand mute, waive any formal readings, Your Honor.
The indication from the Huron Township Department of Public Safety indicates that they do not oppose a personal bond. For that reason, your client's bond will be set at $5,000 personal. Sir, you do not need to post any money, but what you must do is continue to appear in these matters as directed by the court until the case is resolved in its entirety. You indicated 60 days. I indicated that maybe 4 weeks.
Yes, Your Honor. I would.
I'm sorry, Ms. Mandernack.
Your Honor, if it's to provide parents.
Yes, Your Honor.
State your name, sir.
Daryl Morris.
There, Judge Robbins knows me quite well.
No, stay out here for a second until we figure out what's going on. Sit down.
Can you tell my
what's going on? Sit down.
talk to the neighbor?
Mr. Morrissey.
I got police here, Your Honor. I don't know what's going on, and they're harassing me right now. This is my house.
Nobody's harassing you.
What do
We
you?
got a call here. We're trying to figure
Not
it
from
out.
here, from
You
next
need to
door.
listen 4 words and not just come down Fillmore just to bother you.
You did because you're doing it now, and you're violating my rights.
We're not violating.
Well, who called here? Why are you here? Why are you here?
Can somebody go speak with the caller?
You have no reason to be here. None. At all. Look at this, Your Honor.
Excuse me? I'm
Yes,
sorry.
you see what's going on? I'm glad the judge is on here.
So much.
Officer?
No, I'm not involved in this at all.
So as soon as we get that figured out, we'll be out of here.
I just told you I wasn't.
Okay, but we don't know that.
I just told you I wasn't.
It doesn't matter.
I told you. It doesn't matter.
It does matter.
So I'm guilty.
matter.
I'm guilty until innocent. I'm sorry, ma'am. They won't stop talking to me long enough for me to talk
I'm
to you,
sorry.
ma'am. No, I didn't.
Mr. Morrissey,
Yeah, no, by the neighbor. I already talked to her.
We have. We're here now. Let's figure this out.
Yes, ma'am.
what I'm inclined to do is adjourn this matter. If you
I
have
told her,
something
I
more
wish somebody
pressing
would
on
tell
your
me what's going
doorstep
on
right
because
now,
I sent her over because it's a house.
Yes, Your Honor. We got some police matter going on right now. I'm sorry. So.
no,
And I
that's
did
all right. Sir, do what
Yes,
you need to do. Ms. Kraus, what were we doing in this matter this morning?
We were going to waive, Your Honor.
I can't waive with Mr. Morrissey being involved with the police right now.
I don't want
What
to
we'll
either,
do,
Judge.
if you're able to hang around for a minute, I'll have Mr. Morrissey disconnect. If you have a good phone number for him and he concludes his whatever's going on with the police on his porch, if you want to come back on and waive, I'm happy to do it. I can't do it with him being in the throes of something else right now, though.
I understand, Judge.
Thank you, ma'am. I'll see you shortly, hopefully. This is 230498SM, State of Michigan versus Aaron Rogers. May I have your appearance, please?
Morning, Your Honor. Royce Nunley appearing on behalf of the defendants. Mr. Rogers, please state your name for the record.
Unmute
Aaron
yourself,
Rogers.
Mr. Rogers. Thank you. Today is the day and time set for the final pretrial in this matter. The victim in this case is here. Mr. Nunley, have you had the opportunity to speak to prosecutor this morning?
I did, yes. At this time, Your Honor, we're just asking for one more adjournment so that I can speak with a potential witness. Then at our next hearing, we are going to know decisively what we are going to do, whether we'll be studying it for trial or otherwise.
How long of an adjournment, sir?
I don't need, no, Your Honor.
Mr. Williams, you do not need to appear at that next date, next Wednesday, August 2nd at 10:30. You're welcome to, but you are not required.
Okay.
Anything else, Mr. Nunley, in this matter?
Nothing further, Judge.
Thank you. That concludes this matter. Mr. Rogers, I will see you next week. Have a good day, sir.
You too, Judge.
Thank you. This is 220839FY, State of Michigan versus Mosaic Rich. May I have your appearances, please?
This case without prejudice.
Sorry, I had to think about it because there was.
Simply ask if Ms. Kraus could you get Mr. Morrissey to reach out to Ms. Jackson, get in touch with me.
Yes, absolutely.
Thank you. Does that include this
August 2nd. August 2nd at 9 a.m. in person.
Mr. Morrissey, Mr. Morrissey, stop. I
I'm
left
sorry.
you a message in the chat. You need to call our office. We just have some questions, okay? And your court date is being adjourned until next week.
I thought you said
Not next week.
the 9th.
The 9th?
Not next week. It's 2 weeks. Yeah. Yes.
Thank you.
August 9th at 9 a.m. That's live with Judge Oakley in courtroom number 2.
Oh, so we're in person on that one. Is that right, Judge?
In person, yes.
All
Thank
right.
you.
got it. Thank you.
Thank you. Have a good day.
You too, Judge.
Thank you.
What's up, court nerds? Welcome back to Time Served.
Ralph Camp,
Yeah, that is
and I think Mr. Camp's AKA is McClintock.
So the females wanted to call me. I'm not all for that.
So, Mr. McClintock, what's your true and correct name?
Mr. Camp,
Okay,
medical doctors, lawyers, and cops. You figure that out.
okay. It looks like I have a competency evaluation for you, Mr. Camp. I think we looked at this yesterday. And it does indicate that he meets the criteria to proceed with these charges. And so I will go over the charges with you. And they are,
Proceed.
it's a trespassing charge at the Peppermill. And the allegation, sir, is that you willfully returned to the Peppermill property after having been trespassed by Peppermill Security on May 11th, which is within the last 6 months. Did you understand the charge, sir?
Yeah, that's a quarter on the ground across the line. I don't take any of you females anywhere. I live my own life. Affirmative?
So, Mr. McClintock or Mr. Camp, I think you prefer Mr. Camp. You're gonna, if you want.
Stop interrupting.
Okay. All right, so Mr. Camp,
Mr. Camp, stand a little closer to the microphone if you would, then I can hear you better.
I
Thank you.
object, Your Honor.
Okay. So did you understand the trespassing charge at the Peppermill? That's a yes or no question. Mr. Camp, did you understand the trespassing charge at the Peppermill? Mr. Camp, I need an answer from you. That's a yes or no question. Did you understand the trespassing charge at the Peppermill?
Sir, answer the judge's question out loud.
Of course.
All right, sir. And how do you wish to plead to the trespassing charge at the Peppermill?
I'm guilty. I was there.
Okay. And do you understand by entering a plea of guilty, you're giving up your right to have a trial in this matter?
Of course.
All right. And did you understand your trial rights? So, Mr. Camp, did you understand your trial rights?
Mm.
Yeah, I have to have a yes or no answer, sir.
Yes.
Okay. And you understand that by entering, you understand the maximum penalty for a misdemeanor, which is trespassing, could be up to 6 months in jail and or a $1,000 fine. That's a possible penalties. Do you understand those possible penalties?
Yes or no, sir? Yes
I
or no?
object. This is in front of all my peers.
All right, so Mr. Camp, let's get through this.
The fifth, you're using me as the little red square. A push of a button to where
I'm going to tell you, counsel, that I'm concerned about Mr. Camp's competency, even though we have a competency evaluation. I'm uncomfortable in proceeding with Mr. Camp based upon his remarks and my observations of him. So I'll hear from either one of you.
Judge, I have my same thoughts. I don't know if it's malingering, but I had no ability to communicate with him. He would not be able to assist counsel in a trial in this state. I was looking him up, Judge. Looks like we had cases in 2014 and 15, and then nothing, and then 4 cases in 2022. He's been in custody now for over a month, probably because we were waiting on the mental health evaluation. I don't know if Ms. Drake would be willing to dismiss without prejudice, but I agree with your comments.
Ms. Drake?
My concern is he has 2 trespassings set for trial on Monday, the 31st, July 31st in Department 3. We probably didn't find him this morning because he's booked under an alias. I know I've been in contact with Peppermill Security and they're very displeased with Mr. Camp. So I'm not inclined to dismiss it, especially since we have a competency evaluation saying he's competent. Maybe he could enter a not guilty on this one as well, or we could put this one on Monday when he comes and is transported and can talk in person with everybody.
I think that that's probably the wisest decision. So we'll continue your matter till Monday, Mr. Camp. You're going to be transported to the Reno Municipal Court on Monday for trials on other trespassing matters, and we're hopeful that we can get these matters resolved. But I'm deeply concerned about your mental health at this stage of the game. So you're going to be continued till Monday for transport to the Reno Municipal Court. I'm continuing this matter.
Number 31, People versus Donald Taylor, 2278 FC.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Taylor, Your Honor.
Hi, Mr. Taylor. How are you, sir?
How you doing, ma'am?
All right, thank you. Mr. Gaddy, where are we today?
Your Honor, I believe that there, yes, I received additional violations yesterday after I met with Mr. Taylor, so I didn't have a chance to go over them with him.
Okay, I just got that as well. We got it this morning. Mr. Taylor, the probation department has amended their violation. They've requested that the following counts 4, 5, and 6, 7, 8, 9
have been added to your violation report. I'm going to arraign you on those and tell you what the allegations are. As I previously told you or I guess you were in front of Judge Kunke, you are entitled to a hearing as to these, and that Mr. Gaddy will continue to represent you. These are the allegations that they have. Count 4, on January 17th of 2023, you were arguing with an AATA employee, threatening to shoot people, shouted profanities, and told a security officer that you would, and this is in quotes, kick his ass, and lists the Ann Arbor Police Report crime report number. Ann Arbor, condition number 5, Ann Arbor Police Report 232317 indicated that you were slurring your words, unsteady on your feet, and appeared intoxicated. Count 6, you had contact with Ann Arbor Police on 1/17/2023 and failed to report your contact to the probation department within 24 hours. Condition 7, on June 3rd of 2023, it is alleged that you committed the offense of giving false information to a police officer, and that is a pending case in the 14A District Court under docket 23-232-0459OT. Must be a ticket case. Count 8, according to the Ypsilanti Police Report 237025 on 6/3 of 2023, you told the police that you were drunk. And then count 9, according to the Ypsi Police Report 237814 on 6/17.
All rise.
Oh, please be seated. It has to be here, right?
All right, for the jury?
All right, everyone, please be seated. All right, ladies and gentlemen, I'm going to read to you what's called the charge of the court. You do not have to memorize it. You will be given this copy back with you when you begin your deliberations. Charge of the court. Members of the jury, the defendant, Richard Thomas, stands charged in an indictment. I'm sorry, just one moment. Members of the jury, the defendant, Richard Thomas, stands charged in count 1 of the indictment with the offense of indecency with a child by sexual contact alleged to have been committed on or about the 11th day of May 2006 in Bexar County, Texas. The defendant, Richard Thomas, stands charged in count 2 of the indictment with the offense of indecency with a child by sexual contact alleged to have been committed on or about the 23rd day of December 2011 in Bexar County, Texas. The defendant, Richard Thomas, stands charged in count 3 of the indictment with the offense of sexual assault of a child alleged to have been committed on or about the 25th day of December 2011 in Bexar County, Texas. The defendant, Richard Thomas, stands charged in count 4 of the indictment with the offense of sexual assault of a child alleged to have been committed on or about the 1st day of January 2012 in Bexar County, Texas. The defendant, Richard Thomas, stands charged in count 5 of the indictment with the offense of sexual assault of a child alleged to have been committed on or about the 1st day of February 2012 in Bexar County, Texas. To all of these offenses, the defendant has pleaded not guilty. 1, our law provides that a person commits the offense of indecency with a child by sexual contact if, with the child younger than 17 years of age, and not the person's spouse, the person engages in sexual contact with the child or causes the child to engage in sexual contact. 2, child means a person younger than 17 years of age. Spouse means a person who is legally married to another. Sexual contact means the following acts if committed with the intent to arouse or gratify the sexual desire of any person. Any touching by a person, including touching through clothing, of any part of the genitals of a child, or any touching of any part of the body of a child, including touching through clothing with any part of the genitals of a person. 3, our law provides that a person commits the offense of sexual assault of a child if the person intentionally or knowingly causes the penetration of the sexual organ of a child by any means. 4, our law provides that all persons are presumed to be innocent and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. 5, a person acts intentionally or with intent with respect to the result of his conduct when it is his conscious objective or desire to cause the result. A person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious objective or desire to engage in the conduct. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. 6, our law provides that the time of the offense alleged in the indictment must be some date anterior to the presentment of the indictment and not so remote that the prosecution of the offense is barred by limitation. The phrase on or about means that the state is not required to prove that the alleged offense happened on that exact date. There is no limitation period for the offense of sexual assault of a child and indecency with a child by sexual contact. Therefore, it is sufficient if the state proves that the offense as alleged in each count were committed sometime before May 19, 2021, which is the date of the indictment, which is the date the indictment was filed. 7, now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 11th day of May 2006 in Bexar County, Texas, the defendant, Richard Thomas, did intentionally or knowingly engage in sexual contact with Nina Sanchez, a female child younger than 17 years, by touching part of the genitals of Nina Sanchez with the intent to arouse or gratify the sexual desire of any person, then you will find the defendant guilty of the offense of indecency with a child by sexual contact as charged in count 1 of the indictment. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 1. 8, now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 23rd day Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 23rd day of December 2011 in Bexar County, Texas, the defendant, Richard Thomas, did intentionally or knowingly engage in sexual contact with Nina Sanchez, a female child younger than 17 years, by causing Nina Sanchez to touch part of the genitals of Richard Thomas with the intent to arouse or gratify the sexual desire of any person, then you will find the defendant guilty of the offense of indecency with a child by sexual contact as charged in count 2 of the indictment. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 2. 9, now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 25th day of December 2011 in Bexar County, Texas, the defendant, Richard Thomas, did intentionally or knowingly cause the penetration of the sexual organ of Nina Sanchez, a child who was younger than 17 years and not the spouse of Richard Thomas, by Richard Thomas's sexual organ, then you will find the defendant guilty of the offense of sexual assault of a child as charged in count 3 of the indictment. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 3. 10, now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the first day of January 2012 in Bexar County, Texas, the defendant, Richard Thomas, did intentionally or knowingly cause the penetration of the sexual organ of Nina Sanchez, a child who was younger than 17 years and not the spouse of Richard Thomas, by Richard Thomas's sexual organ, then you will find the defendant guilty of the offense of sexual assault of a child as charged in count 4 of the indictment. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 4. 11, now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the first day of February 2012 in Bexar County, Texas, the defendant, Richard Thomas, did intentionally or knowingly cause the penetration of the sexual organ of Nina Sanchez, a child who was younger than 17 years and not the spouse of Richard Thomas, by Richard Thomas's sexual organ, then you will find the defendant guilty of the offense of sexual assault of a child as charged in count 5 of the indictment. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 5. In this case, there was evidence presented of more than one alleged instance that could constitute an offense committed by the defendant, if any. You are instructed that your verdict on each count must be unanimous about which specific instance, if any, constituted the commission of the offense for purposes of each of the individual counts. You are to consider only that one act as alleged in the indictment by the state in deciding guilt or innocence on that particular count. Evidence of any other alleged act evidence of any other alleged acts is not to be considered unless you believe those acts were committed beyond a reasonable doubt. With regard to those other acts, if any, you are instructed that said evidence was admitted only for the purpose of showing the state of mind of the defendant and the child and the previous and subsequent relationship between the defendant and the child, if it does, and for no other purpose. You are also instructed that generally the results of polygraph tests are inadmissible in a criminal prosecution on behalf of the state or the defense. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet, or computer the internet, any internet service or any text or instant messaging service or any social media platform, internet chat room, blog, or website to include, but not limited to, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, or Twitter to communicate with anyone any information or receive any information from anyone about this case or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or officers or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You're instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court, and these instructions are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You're instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether the defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any role in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict on each count, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive the law from the court, which is hearing given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement, if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdicts are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict on each count must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the bailiff. Any and all communication relative to the case must be written prepared by the presiding juror and submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas. Suitable forms are attached. State, are you prepared to proceed?
Yes, Your Honor.
All right, you may proceed.
May it please the court, opposing counsel, co-counsel, ladies and gentlemen of the jury. I'm going to go over a few technical matters with you, and then once I'm done, defense will have their time to talk, and Ruben will come after that and make further arguments. So let's start with the technical matters. We're talking about indecency with a child, and here are the elements. On or about some date anterior to the indictment, which is May 19th, 2021, in Bexar County, Texas, the defendant did intentionally or knowingly engage in sexual contact, touching the genitals, anus, or female breasts. It could be over or under the clothes with a child younger than 17 years of age with the intent to arouse or gratify the sexual desire of any person. Those are the elements that the state must prove beyond a reasonable doubt. And those are the elements that the state has proven beyond a reasonable doubt. You've heard from Nina, and you've also heard from the defendant in his confession. He confessed to doing all those things. I think the only thing that's not in the confession perhaps is that it was in Bexar County, Texas, and you heard from Nina. There's basically no dispute about where these accusations occur. So you have that with you in the jury, the confession, and I urge you to read it and understand exactly what he confessed. The other charge that you'll be deliberating on in the jury room is sexual assault of a child. And we're talking about on or about some date anterior to the indictment, same as the last one. In Bexar County, Texas, same as the last one. Defendant, same as the last one, intentionally or knowingly cause the penetration of the sexual organ, mouth, or anus of a child under 17 years of age. So it's a little bit different. And as you'll see in the indictment, the allegations are alleging this happened in a different time period. The indecency charges counts are earlier in time, and then later in time, there's the allegations of the sexual assault of a child. So one thing I don't want you guys to get hung up on
2 minutes
is that first section about the jury has to agree that it's on the a date anterior to the date of the indictment. That's May 19th, 2021. As long as it's before that date, that's what's required by law. The legislature understood that the exact date might not always be known in these cases, and every instance that Nina talked about was before that date. And I want to remind you that you're the sole decider of the credibility of all the witnesses that were in front of you. Their testimony is evidence, so any testimony that you believed, you can consider in your deliberations. And the state's position is that Richard's relatives who came in to testify on his behalf were not credible witnesses. They all said that to the idea of whether you should lie for personal gain, they all said it depends. And I think if somebody has that kind of moral, they're not solid in their moral position on lying for personal gain, this is the exact situation where someone would come out and lie for personal gain. This is it, folks. This is when they would come and do that. And so I don't think you can trust them, and I don't think what they said was all that credible. They just seem to have a lot of it depends when asked about whether lying was an acceptable thing to do. And I also want to point out before I go that this is about Nina, and that she was abused by Richard Thomas, and the adults in her life failed her. And they failed her pretty badly. Her mother, the CPS workers, all allowed her to continue to get abused even after Richard admitted that he abused her. And defense said that in their opening that Richard has been waiting a long time for this, and I'll tell you, so has Nina. And don't fail Nina. Please find Richard guilty. And I reserve the rest of my time.
Okay. Defense?
Please support.
Yes.
Counselors, ladies and gentlemen of the jury. I'm not here to tell you who to believe. That's up to you. Entirely up to you. And for that, our founding fathers believed the system, and I believe the system. What I am going to ask you is to review that supposed confession. In the law was given by the court says here, notice, with the intent to arouse or gratify the sexual desire of any person. My client can even spell gratify. He has no degree. He couldn't have written that. That was given to him by Barbara. He signed to get his children. You know, I understand that all these allegations are serious. In fact, I told you, Nina needs help. Told you that from the very beginning. There's no question. This child has been hurt. This child, time and time and time again, continued to make allegations. This child has herself done what she's accusing my client of doing. You heard it. Again, I'm not telling you what to believe. I'm just, those are the facts. And the law does not require Richard to prove anything. He doesn't have to. But he wanted you to hear from him why he confessed. By the way, again, read it. It's verbatim. To arouse and gratify the sexual desire of a person. He has no clue what that means. Has no GED, has no high school. He's just a hardworking man looking for his family to provide and protect. And because a child that is troubled, make no mistake about it, she's troubled, makes these accusations. Here we are once again. You heard the evidence say that she recanted. That means she changed her story. Wait, no, it didn't happen. This is when that statement that he signed in 2007, she recanted that. And yet, here we are, 16 years later. He couldn't even count. He said 23. 16 years, ladies and gentlemen of the jury. This thing has been going on for 16 years, accusation after accusation after accusation. Poor Nina. She is troubled. In her mind, she has created this fantasy that she's been having a relationship with her stepfather. She's perhaps jealous of the relationship with her mother. Troubled child. And the prosecution wants you to believe one sheet of paper. You're going to take it with you. One sheet of paper. A confession. He confessed. That's it. Makes you wonder what kind of system we are in which that type of behavior. Detective didn't question anyone. 1 hour he spent with her. Oh, she said she's telling the truth. 1 hour. Barbara, 1 hour. That's it. No investigation. No following up, no calling her schools, friends, classmates. Hey, is Nina telling the truth? We believe her. The judge just gave you the instruction that polygraphs are generally inadmissible. Read the letter. It was a result of a polygraph investigation in which the examiner makes you lie. Then ask you on the examination, have you lied? No, because you're telling me to lie. Oh, there you are. You failed the polygraph test. Ladies and gentlemen of the jury, I suggest to you that if you have children taken away from you and you're dangling something in front of you that says, here, sign this and you got it. He say that he read it. I doubt it. In fact, I bet you if I make him read it, he wouldn't even know how to pronounce half of the words. This is difficult to do when you have people facing you, when you have prosecutors accusing you, when you have the whole world saying you're just guilty. I get it. This type of cases, I get it. I'm asking you to do the honorable thing to do that I requested from each and every one of you. Stand firm. The prosecution has to prove to you. Not me. But yet here we did. We brought you, like Paul Harvey says, the rest of the story. Nina has issues. She said it. She's examining her sexuality since 14. She said it. I did it. This is hard. I get it. It's hard. I get it. but not creating an environment in which the whole family is affected by lies. Ladies and gentlemen, this has been time and time again dealt with by the court system. You heard he was in jail. And yet she recanted. Oh no, that's because mom forced her, because grandma forced her. That's the type of story that she creates. And when a person tells the lie time and time again, eventually you believe it. And the story gets bigger and bigger and more detailed. Guys, this is 16 years that she remembers to all this detail. And notice how the prosecution is asking you, oh, sometime between here and there. I asked my children, hey, do you remember that time that you ate that ice cream that you weren't supposed to? Oh, wait, I was 11, I was 12 or 13. No, I don't remember. You heard her 10, 11, 12, 8. Guys, when things like this happen, remember. And the most compelling thing is when something like this happened to you, truly happened to you, you want to get revenge, don't you? You heard her. She doesn't want him to go to jail. It's a fantasy. Oh, she wants him to get registered. No, ladies and gentlemen of the jury, if something like this happened, throw the key and don't just, but it didn't happen. That's why she's giving you the ability to put him on probation. Just don't put him in jail. Ladies and gentlemen, see through the facade and notice how much, I allowed him to talk and the prosecution was objecting, didn't let me ask many questions. I hope you notice that. Because when your case is based on a sheet of paper, I propose that it's thin and is full of reasonable doubt. We don't have a definition. You get to say what is reasonable doubt, but question each and every instance. Question why the detective did not follow up. Question why Barbara had him say the same language the same verbatim. Ask why would anyone, if heard, will tell the perpetrator or the alleged perpetrator, that's okay, you can just be a register, don't go to jail. Only if this is a story in your head, a facade that you just want to, like a story, a love story. Oh, I believe she's in love with him for some reason. She needs help, ladies and gentlemen. But the court says, do not feel sympathy. You're not here because do not let, the court instructed, you are not to let bias, prejudice, sympathy. I feel sympathy for her. She needs help. But we cannot have that ruling based on that. I despise sexual predators. They need to be taken care of, but not honest men based on a paper thin confession and based on a story that continues to be bigger and bigger. Ladies and gentlemen, she said that this story was recanted. She said it, not over here. Finally, please notice that confession, if you remember, the prosecution wanted to hide that paper, and we had a discussion, Exhibit 2 and 2A. It's the only exhibit you have, 2A. They wanted to redact that part about the polygraph. That's how it was obtained, through a polygraph. You are also instructed generally the results of a polygraph test are inadmissible, either for the criminal prosecution or the defense. This is why you didn't see the actual polygraph. It's inadmissible. Yet, that confession is because of it. Does that make sense? Only when a person feels so much empathy, will a person believe a story as grand as Nina. I mean, she's having sex, losing her virginity, and she's standing up I have girls. And I don't ask about those questions, but I know that there's some parts of their story that it just makes no sense. If at 14, she had blood and she had semen, why didn't she say, Mom, I've been telling you all these years, here it is. Go take that to the, never happened. It's the only plot. If you have the person that is abusing you, supposedly, now you have proof. Oh, well, it's not there. Again, she had the time to truly get this done. The investigators had the time, everybody. When the prosecutor says they failed, the system has failed, the state has failed, truly. Because this case should have been dismissed. They knew this. They knew that she recanted her story. They knew that she's got some issues. They're expecting a juror of his peers to feel sorry for her. And make no mistake, I told you from the very beginning, she needs help. She needs help. But please, do what you said you were going to do. Stand firm for our founding fathers' values, that he is innocent until proven guilty. They have to prove him guilty. I believe that a piece of paper doesn't do it. That's the only thing you're going to be able to take back. That's it. And you're going to see that it matches exactly what the indictment says. Something that Richard could have never thought about saying, other than against his children. I understand that that sounds very far-fetched, but that's what happened. The state, CPS, call it placement, remove them. Those children were not at their residence, period, where they're supposed to be sleeping at night. And for them to come back, I needed something from him. And they got it. And here we are, 16 years later. Ladies and gentlemen, this is the jury,
2 minutes.
Thank you, Your Honor. The credibility of each witness is up to you. The weight of the evidence is up to you. I'm going to ask you when you go back to stand firm, just like the judge is asking you. Don't be persuaded, but you can change your opinion, but fight. If something inside of you telling you this is not right, fight. Do not give up because you want to go home Friday. Trust me, I want to go home, but I want this to be done properly. Now it's up to y'all. Y'all to come up with a verdict. Find my client not guilty 5 times because the story, he is not guilty. You saw him. He told you this is in Nina's head. Find him not guilty. Thank you so very much. My client thanks you. The family thanks you. May God bless you and may God bless the United States of America.
All right, state.
Ladies and gentlemen of the jury, there's only one facade that's being pushed to you here today. And that's the facade that the defendant wants you to believe. He wants you to believe that he was coerced into a confession to sexually abusing one of the kids that was in his care, and that he was going to get his children back after admitting to sexually abusing one of them. Does that make sense to anybody in this courtroom other than the defendant? The defense is trying to confuse you with multiple different arguments about what could have happened. Why could Nina have done this? There's only one thing at issue in this case, and that's what the defendant did to Nina on 5 different occasions. You have the confession, which the defense is making a big point about. And I want you to remember one thing. That confession came from the defendant calling up Belinda Castellanos, asking her for a meeting so he can come in and confess. And Belinda told you he didn't write that, they wrote it, but they gave him every opportunity to read it, edit it for its truthfulness before he signed it, and signed in front of a witness as well. So consider that. You also heard Nina's testimony, and she has been consistent from the beginning. She told all of you that starting in 2006, there was only touching, which is corroborated by the defendant's own confession. Defense made a big deal about the dates and how she was still a virgin in 2006. Well, of course she was, because she's never told anybody anything different. The sexual abuse, the sexual penetration didn't start until 2011 after she turned 14. She told you all that, and that's corroborated by their own arguments. She was able to tell you that the first time she had sex with the defendant, when she lost her virginity, she was standing up. She remembered that detail. She told you in 2006, she remembers when he put his genitalia on her back, she felt it wet through her clothes. She remembered that detail. She has remembered details from each incident through 16 years that this has been going on. Her testimony is credible. None of her testimony has changed over the 16 years. And sure, she does have some flaws. She's not a perfect person, and she never claimed to be. She told you all upfront and honestly that she engaged in a relationship with the defendant when she was under the age of 17 years old. She admitted all of that. Why would she admit that if it wasn't true? Wouldn't it be more reasonable to believe that she was raped? And if she really wanted to make a lie and have people believe her, isn't that a little bit more believable? No, but she was honest with each and every one of you and told you that it was consensual. But again, remember, she's under the age of 17. She can't consent. But you know who should know right from wrong? The defendant. She admitted to running away. But what else would you expect from a child who's not protected by her parents? She's in a home where this abuse is being allowed to happen. What other choice does she have? And she admitted to not even being the perfect sister to Jacqueline. She admitted she harmed her physically. But the defense wants to throw out that she was sexually abusing Jacqueline. Where is the report? Where is any evidence that anything sexual happened between any of them other than Jacqueline's testimony? Who I will also remind you, as Travis told you, said that it depends whether or not you should lie in order to benefit yourself. You can't believe anything she said. And who has the motive to lie here? Does Nina? The defendant's not in her life anymore. She has no reason to get back at him. Her mom's not in her life anymore. She has no reason to get back at her. If she's trying to get him out of her life, he already is. You know who has the motive to lie here? The defendant. Because he's the one on trial here. He's the one that's facing time in prison. So of course he's gonna lie. And his own family told you that sure, it depends. Maybe you should lie when it's gonna benefit yourself. Each and every one of them told you that on the stand. But you know what they also said? They also said they wouldn't admit to a crime that they didn't do, which is what the defendant wants you to believe he did. He wants you to believe he never did this, but he admitted to it to get his children back. First of all, again, that makes no sense. How would you put children back in the care of someone who just admitted they sexually abused a child? You also heard from Belinda that nobody took the children away from them. Santa took the children to her mother's house to get away from the defendant after he admitted that he sexually abused Nina. Ladies and gentlemen, use your common sense when you evaluate that confession. Does the defendant's story make sense? Or does it make more sense that he did that and wanted to confess to it? Everybody's been talking about failures today. And yes, Nina's been failed by all of the adults in her life. She was failed by the defendant, her stepdad, who sexually abused her and manipulated her family against her to the point where none of them believe her and are on her side. She's failed by her mother, who failed to protect her from the sexual abuse and allowed her admitted, confessed sexual abuser back into the home. And that was before the sexual abuse, the sexual penetration even occurred. She was failed by CPS, who, under the wrong assumption that Santa was going to protect Nina, allowed Nina back into the home. And they didn't follow up to know whether or not the defendant was back in the home. I'm urging all of you to not be an additional step of failure in Nina's life. She told you that she's okay with him getting probation.
Yes, I'm gonna object improper jury commitment. And the closing argument, Your Honor.
All right, overruled.
She said she's okay with probation because, like I said, she has nothing to gain. The defendant's already out of her life. What's the difference to her if he's in prison or not? But you don't have to consider that at this point. What I'm asking you to do is find the defendant guilty on all 5 counts and hold him accountable for his actions, which is what Nina said that she's still here 16 years later to do, even though she gets no benefit from this. Thank you.
All right, ladies and gentlemen, I'm going to let you retire back to the jury room. I'm going to ask for Alonso and Sosa, if you could remain behind, please. Everyone, please rise for the jurors. Please be seated. If I could see defense and state. Instructions still apply to both of you. You're not allowed to do anything. You're not allowed to start deliberating in terms of each other. Everything that you need to know about this case is coming from inside the children. You won't be allowed to go back and them to deliberate either. Okay. So Deputy Laura's will let you know place for hang out. And then we'll call you if you're needed. So it's something where it happens to one of the jurors. Then we'll let you in preparation with them, okay? Yes, Deputy Laura will take you to get those images, taking them back there, get them along. All right. All right.
I think Joseph.
Oh, and I found it in some others. It was hidden.
I didn't like, I mean, it wasn't a problem. Well, no, I mean, just like I should have known that it would have taken more than 2 minutes so that I wouldn't feel rushed when I got my 2-minute warning.
All right, Diane, are you ready? And then later, I guess you need to do the exhibits.
Yes.
All right. Oh, I'm so sorry, guys. Yes, she's gonna give the exhibits and just remember 2 is not going back there. Yes. Oh, only 2A, was it Bennett?
Yes, ma'am.
Oh, okay. Yeah. All right, Mr. Aguilar, if you want to come down. And then Hank, if you'll just ask that this be added to the STIPs. And has your client had a chance to see what's being added to the STIPs? Okay. 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 All right. All right. You ready? We're going to go back on the record in 2023 CR 4007A, State of Texas versus Mario Aguilar. Can I have parties announced for the record for the state? Okay. And with regards to the waivers and stipulation of testimony and stipulation state, any additions?
Yes, Your Honor, we would like to, amend Stacy to the one to add the prosecutor's side, given the defense that they.
Any objection?
Your Honor, we have no objections.
All right. And you understand what's being added, Mr. Aguilar? All right. The court will find, based upon state's exhibits 1 and attachments and the stipulations what the court has is accepting the record, and the court is finding that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will find there's sufficient evidence to find the defendant guilty. The court will defer finding of guilt because the defendant has applied for deferred adjudication. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client? So how old are you? Do you have any children? All right. Any drug issues for you? Are you employed? Have you ever been employed? Doing what?
Working at a restaurant, going on painting, remodeling,
All right. And how far did you go in school?
high school.
Did you graduate? Why not?
I got into a program and learning academy and else I can go to work.
Okay. All right. And I see that he is a resident and not a citizen. All right. So whether or not the federal government removes you, that's under their purview. That is not my purview. I do not have any control over that. Do you understand? And legally, I cannot remove you. You understand? All right. Yes. Mhm. So does he have a hold?
He has a hold, but he's released on the bond.
All right. There's going to be a $500 fine. That will be probated. 8 years deferred adjudication. There's to be no contact with Emmanuel Nathaniel Morley, Morley Jr. There's to be no contact with Charles Williams. There's to be the theft course and the MRT course. Is there any restitution that's due to the complainant?
No, Your Honor,
There should be regular reporting by Zoom or in person regular UAs. If you were released, who are you living with? All right. So probation,
Yes, Your Honor.
if he is released by the federal government and they put him on the monitor, then it's fine for us to just have him on that monitor. But if he is not released without a monitor, then we will put him on a monitor. And that will be 90 days GPS. And it'll be partial for work. There's to be 200 hours of community service restitution. Those hours will be waived if you obtain your GED or if you're in some sort of trade school. You need to have some sort of skill so that you can have employment. You understand? And you say you're residing with your grandmother. Does your grandmother want you residing with her? Did you ask her?
Already, when I came from immigration, that's what I had to say.
Okay. Defendant to reside with grandmother. Is that your maternal grandmother or paternal grandmother? Is it your mother's mother or your father's? Okay. So he's to reside with his maternal grandmother upon verification. There's to be proof of employment. Within 40 days of release. There's to be no employment as a home health care provider or with minors. Probation, is there anything else he needs?
Your Honor, do you want any field visits?
Yes. Let's do field visits. One time per month for 3 months. And then if probation feels that everything is going as it should be, then you can do those randomly. All right, is there anything else, probation?
No, Your Honor.
All right, is there anything else you need from the court to be successful?
No, Your Honor.
Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Look, you're a resident. Maybe they're going to deport you. Maybe they will not deport you. But while you are here, you need to do better. You understand?
Yes, Your Honor.
People already have an eye on you because you're a resident and you're not a citizen. You make it harder for other people when they are residents and they're doing the right thing. Because then people are, there goes another resident who's committing an offense. There goes somebody who's not a citizen who's committing an offense. And you make sure that people are able to paint a brush that residents and that people who are not here are not doing what they're supposed to do and are not being law-abiding people. Do you understand?
Yes, Your Honor.
You're going to have to do better. You understand?
Yes, Your Honor.
And do not go to your grandmother's house if you are released and cause problems for her, because she does not need any trauma or drama coming to her doorstep. You understand?
Yes, Your Honor.
And if you're going to be staying with her, guess what? You're not an adult. You need to follow her rules. If she tells you she wants the television off by 10, that TV needs to be off by 10. If she tells you she doesn't want any of your friends coming over, then your friends can't come over because that's not your house. That's her house. You are now an adult. You understand?
Yes, Your Honor.
All right, do better. Good luck to you.
Thank you, Your Honor.
Oh, by the way, do you need anything else from the court?
No, Your Honor.
All right, what's that? I just noticed. What's that tattoo on your hand?
What are you saying?
All right, do a gang evaluation as well, please.
Yes, Your Honor.
Thank you.
Thank you, Judge. Let me excuse, Judge.
Yes, you may. Thank you so much for coming back.
Of course, Judge. Have a good weekend.
All right, you too. And I think that's the last person we have on the docket.
Yes, ma'am.
All right, thank you. Good seeing you. It's, yes.
Okay, good deal. I've got a fellow who didn't show up for PTD, so I just want to make sure he's.
Hello, hello, hello. This is Attorney Mike Grevlin coming to you from Chicago. As usual, we got a fun one today. It's a little bit longer because I put two hearings together. Somebody sent this to me and I can't find who, and I apologize for that, but thank you because I really like it. And then I found the second clip, which is what makes this a little bit longer, but it's the follow-up that you would all ask for. So I thought, there's no other way to do it. Just put them together and run through. So we're gonna have ourselves a fun late night hangout. I don't know how this time slot will work, but this is all I had for the day, and this is a fun clip. So let's get it started and see where we go here.
Yes, ma'am. Yes, ma'am.
All right, Mr. Leva and Ms. Leva Pike, if you would mute yourselves and raise your right hands, please. Ms. Leva Pike, would you unmute yourself and raise your right hand, please?
Strong start here.
Are you frozen?
Oh, can you hear me?
I can hear you, but you look to be frozen. Are you frozen?
Your Honor, can you hear me?
I can hear you.
Thank you, Judge.
Everyone, just a moment for me.
All rise.
Oh, please be seated.
He has no high school. He's just a hardworking man, looking for his family to provide and protect.
Suitable forms.
The state must prove beyond a reasonable doubt. And
Consider only that one act as alleged in the indictment by the state is not to be considered for media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet, or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, or Twitter, to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You're instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court, and these instructions are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You're instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether the defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any role in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict on each count, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive the law from the court, which is hearing given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement, if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict not guilty. Suitable forms for your verdicts are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict on each count must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the bailiff. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas. Suitable forms are attached. State, are you prepared to proceed?
Yes, sir.
All right, you may proceed.
May it please the court, opposing counsel, co-counsel, ladies and gentlemen of the jury. I'm going to go over a few technical matters with you, and then once I'm done, defense will have their time to talk, and Ruben will come after that and make further arguments. So let's start with the technical matters. We're talking about indecency with a child, and here are the elements. On or about some date anterior to the indictment, which is May 19th, 2021, in Bexar County, Texas, the defendant did intentionally or knowingly engage in sexual contact, touching the genitals, anus, or female breasts. It could be over or under the clothes with a child younger than 17 years of age with the intent to arouse or gratify the sexual desire of any person. Those are the elements that the state must prove beyond a reasonable doubt. And those are the elements that the state has proven beyond a reasonable doubt. You've heard from Nina, and you've also heard from the defendant in his confession. He confessed to doing all those things. I think the only thing that's not in the confession perhaps is that it was in Bexar County, Texas, and you heard from Nina. There's basically no dispute about where these accusations occur. So you have that with you in the jury room, the confession, and I urge you to read it and understand exactly what he confessed. The other charge that you'll be deliberating on in the jury room is sexual assault of a child. And we're talking about on or about some date anterior to the indictment, same as the last one. In Bexar County, Texas, same as the last one. Defendant, same as the last one, intentionally or knowingly cause the penetration of the sexual organ, mouth, or anus of a child under 17 years of age. So it's a little bit different. And as you'll see in the indictment, the allegations are alleging this happened in a different time period. The indecency charges counts are earlier in time, and then later in time, there's the allegations of the sexual assault of the child. So one thing I don't want you guys to get hung up on
2 minutes.
is that first section about the jury has to agree that it's on the a date anterior to the date of the indictment. That's May 19th, 2021, as long as it's before that date. That's what's required by law. The legislature understood that the exact date might not always be known in these cases. And every instance that Nina talked about was before that date. And I want to remind you that you're the sole decider of the credibility of all the witnesses that were in front of you. Their testimony is evidence. So any testimony that you believed, you can consider in your deliberations. And the state's position is that Richard's relatives who came in to testify on his behalf were not credible witnesses. They all said that to the idea of whether you should lie for personal gain, they all said it depends. And I think if somebody has that kind of moral, they're not solid in their moral position on lying for personal gain, this is the exact situation where someone would come out and lie for personal gain. This is it, folks. This is when they would come and do that. And so I don't think you can trust them, and I don't think what they said was all that credible. They just seem to have a lot of it depends when asked about whether lying was an acceptable thing to do. And I also want to point out before I go that this is about Nina, and that she was abused by Richard Thomas, and the adults in her life failed her. And they failed her pretty badly. Her mother, the CPS workers, all allowed her to continue to get abused even after Richard admitted that he abused her. And defense said that in their opening that Richard has been waiting a long time for this, and I'll tell you, so has Nina. And don't fail Nina. Please find Richard guilty. And I reserve the rest of my time.
Spence?
Please support.
Yes.
Counselors, ladies and gentlemen of the jury. I'm not here to tell you who to believe. That's up to you, entirely up to you. And for that, our founding fathers believed the system, and I believe the system. What I am going to ask you is to review that supposed confession. In the law was given by the court, says here, notice, with the intent to arouse or gratify the sexual desire of any person. My client can even spell gratify. He has no degree. He couldn't have written that. That was given to him by Barbara. He signed to get his children. You know, I understand that all these allegations are serious. In fact, I told you, Nina needs help. I told you that from the very beginning. There's no question. This child has been hurt. This child, time and time and time again, continued to make allegations. This child has herself done what she's accusing my client of doing. You heard it. Again, I'm not telling you what to believe. Those are the facts. And the law does not require Richard to prove anything. He doesn't have to. But he wanted you to hear from him why he confessed. By the way, again, read it. It's verbatim. To arouse and gratify the sexual desire of a person. He has no clue what that means. Has no GED, has no high school. He's just a hardworking man looking for his family to provide and protect. And because a child that is troubled, make no mistake about it, she's troubled, makes these accusations, here we are once again. You heard the evidence say that she recanted. That means she changed her story. Wait, no, it didn't happen. This is when that statement that he signed in 2007, she recanted that. And yet here we are, 16 years later. He couldn't even count. He said 23. 16 years, ladies and gentlemen of the jury. This thing has been going on for 16 years. Accusation after accusation after accusation. Poor Nina. She is troubled. In her mind, she has created this fantasy that she's been having a relationship with her stepfather. She's perhaps jealous of the relationship with her mother. Troubled child. And the prosecution wants you to believe one sheet of paper. You're going to take it with you. One sheet of paper. A confession. He confessed. That's it. Makes you wonder what kind of system we are in which that type of behavior. Detective didn't question anyone. 1 hour he spent with her. Oh, she said she's telling the truth. 1 hour. Barbara, 1 hour. That's it. No investigation, no following up, no calling her schools, friends, classmates. Hey, is Nina telling the truth? We believe her. The judge just give you the instruction that polygraphs are generally inadmissible. Read the letter. It was the result of a polygraph investigation in which the examiner makes you lie, then ask you on the examination, have you lied? No, because you're telling me to lie. Oh, there you are. You failed the polygraph test. Ladies and gentlemen of the jury, I suggest to you that if you have children taken away from you and you're dangling something in front of you that says, here, sign this and you got it. He say that he read it. I doubt it. In fact, I bet you if I make him read it, he wouldn't even know how to pronounce half of the words. This is difficult to do when you have people facing you, when you have prosecutors accusing you, when you have the whole world saying you're just guilty. I get it. This type of cases, I get it. I'm asking you to do the honorable thing to do that I requested from each and every one of you. Stand firm. The prosecution has to prove to you. Not him. But yet here we did. We brought you, like Paul Harvey says, the rest of the story. Nina has issues. She said it. She's examining her sexuality since 14. She said it. I did it. This is hard. I get it. It's hard. I get it. But not creating an environment in which the whole family is affected by lies. Ladies and gentlemen, this has been time and time again dealt with by the court system. You heard he was in jail. And yet she recanted. Oh no, that's because mom forced her, because grandma forced her. That's the type of story that she creates. And when a person tells the lie time and time again, eventually you believe it. And the story gets bigger and bigger and more detailed. Guys, this is 16 years that she remembers to all this detail. And notice how the prosecution is asking you, oh, sometime between here and there. I asked my children, hey, do you remember that time that you ate that ice cream that you weren't supposed to? Oh, wait, I was 11, I was 12 or 13. No, I don't remember. You heard her. 10, 11, 12, 8, 9. Guys, when things like this happen, remember. And the most compelling thing is when something like this happened to you, truly happened to you, you want to get revenge, don't you? You heard her. She doesn't want him to go to jail. It's a fantasy. Oh, she wants him to get registered. No, ladies and gentlemen of the jury, if something like this happened, throw the key and don't just. But it didn't happen. That's why she's giving you the ability to put him on probation. Just don't put him in jail. Ladies and gentlemen, see through the facade and notice how much, I mean, I allow him to talk and the prosecution objecting, didn't let me ask many questions. I hope you notice that. Because when your case is based on a sheet of paper, I propose that it's thin and is full of reasonable doubt. We don't have a definition. You get to say what is reasonable doubt, but question each and every instance. Question why the detective did not follow up. Question why Barbara had him say the same language as, the same verbatim. Ask why would anyone, if heard, will tell the perpetrator or the alleged perpetrator, that's okay, you can just be a register, don't go to jail. Only if this is a story in your head, a facade that you just want to, like a story, a love story. Oh, I believe she's in love with him for some reason. She needs help, ladies and gentlemen. But the court says, do not feel sympathy. You're not here because do not let, the court instructed, you are not to let bias, prejudice, sympathy. I feel sympathy for her. She needs help. But we cannot have that ruling based on that. I despise sexual predators. They need to be taken care of, but not honest men based on a paper thin confession and based on a story that continues to be bigger and bigger. Ladies and gentlemen, she said that this story was recanted. She said it, not over here. Finally, please notice that confession, if you remember, the prosecution wanted to hide that paper, and we had a discussion, Exhibit 2 and 2A. It's the only exhibit you have, 2A. They wanted to redact that part about the polygraph. That's how it was obtained, through a polygraph. You are also instructed generally the results of a polygraph test are inadmissible, either for the criminal prosecution or the defense. This is why you didn't see the actual polygraph. It's inadmissible. Yet, that confession is because of it. Does that make sense? Only when a person feels so much empathy would a person believe a story as grand as Nina. I mean, she's having sex, losing her virginity, and she's standing up. I have girls, and I don't ask about those questions, but I know that there's some parts of their story that it just makes no sense. If at 14, she had blood and she had semen, why didn't she say, Mom, I've been telling you all these years, here it is. Go take that to the, never happened. It's the only plot. If you have the person that is abusing you, supposedly, now you have proof. Oh, well, it's not there. Again, she had the time to truly get this done. The investigators had the time, everybody. When the prosecutor says they failed, the system has failed, the state has failed, truly, because this case should have been dismissed. They knew this. They knew that she recanted her story. They knew that she's got some issues. They're expecting a juror of his peers to feel sorry for her. And make no mistake, I told you from the very beginning, she needs help. She needs help. But please, do what you said you were going to do. Stand firm for our founding fathers' values, that he is innocent until proven guilty. They have to prove him guilty. I believe that a piece of paper doesn't do it. That's the only thing you're going to be able to take back. That's it. And you're gonna see that it matches exactly what the indictment says. Something that Richard could have never thought about saying, other than against his children. I understand that that sounds very far-fetched, but that's what happened. The state, CPS, call it placement, removed them. Those children were not at their residence, period, where they're supposed to be sleeping at night. And for them to come back, I needed something from him. They got it. And here we are, 16 years later. Ladies and gentlemen, the jury,
2 minutes.
thank you, Your Honor. The credibility of each witness is up to you. The weight of the evidence is up to you. I'm gonna ask you when you go back to stand firm, just like the judge is asking you. Don't be persuaded, but you can change your opinion, but fight. If something inside of you telling you this is not right, fight. Do not give up because you want to go home Friday. Trust me, I want to go home, but I want this to be done properly. Now it's up to y'all to come up with a verdict. Find my client not guilty 5 times because the story, he is not guilty. You saw him. He told you this is Nina's head. Find him not guilty. Thank you so very much. My client thanks you. The family thanks you. May God bless you and may God bless the United States of America.
Right, state.
Ladies and gentlemen of the jury, there's only one facade that's being pushed to you here today. And that's the facade that the defendant wants you to believe. He wants you to believe that he was coerced into a confession to sexually abusing one of the kids that was in his care, and that he was going to get his children back after admitting to sexually abusing one of them. Does that make sense to anybody in this courtroom other than the defendant? The defense is trying to confuse you with multiple different arguments about what could have happened. Why could Nina have done this? There's only one thing at issue in this case, and that's what the defendant did to Nina on 5 different occasions. You have the confession, which the defense is making a big point about. And I want you to remember one thing. That confession came from the defendant calling up Belinda Castellanos, asking her for a meeting so he can come in and confess. And Belinda told you he didn't write that, they wrote it, but they gave him every opportunity to read it, edit it for its truthfulness before he signed it, and signed in front of a witness as well. So consider that. You also heard Nina's testimony, and she has been consistent from the beginning. She told all of you that starting in 2006, there was only touching, which is corroborated by the defendant's own confession. Defense made a big deal about the dates and how she was still a virgin in 2006. Well, of course she was, because she's never told anybody anything different. The sexual abuse, the sexual penetration didn't start until 2011 after she turned 14. She told you all that, and that's corroborated by their own arguments. She was able to tell you that the first time she had sex with the defendant, when she lost her virginity, she was standing up. She remembered that detail. She told you in 2006, she remembers when he put his genitalia on her back, she felt it wet through her clothes. She remembered that detail. She has remembered details from each incident through 16 years that this has been going on. Her testimony is credible. None of her testimony has changed over the 16 years. And sure, she does have some flaws. She's not a perfect person, and she never claimed to be. She told you all upfront and honestly that she engaged in a relationship with the defendant when she was under the age of 17 years old. She admitted all of that. Why would she admit that if it wasn't true? Wouldn't it be more reasonable to believe that she was raped? And if she really wanted to make a lie and have people believe her, isn't that a little bit more believable? No, but she was honest with each and every one of you and told you that it was consensual. But again, remember, she's under the age of 17. She can't consent. But you know who should know right from wrong? The defendant. She admitted to running away, but what else would you expect from a child who's not protected by her parents? She's in a home where this abuse is being allowed to happen. What other choice does she have? And she admitted to not even being the perfect sister to Jacqueline. She admitted she harmed her physically, but the defense wants to throw out that she was sexually abusing Jacqueline. Where is the report? Where is any evidence that anything sexual happened between any of them other than Jacqueline's testimony? Who I will also remind you, as Travis told you, said that it depends whether or not you should lie in order to benefit yourself. You can't believe anything she said. And who has the motive to lie here? Does Nina? The defendant's not in her life anymore. She has no reason to get back at him. Her mom's not in her life anymore. She has no reason to get back at her. If she's trying to get him out of her life, he already is. You know who has the motive to lie here? The defendant. Because he's the one on trial here. He's the one that's facing time in prison. So of course he's gonna lie. And his own family told you that sure, it depends. Maybe you should lie when it's gonna benefit yourself. Each and every one of them told you that on the stand. But you know what they also said? They also said they wouldn't admit to a crime that they didn't do, which is what the defendant wants you to believe he did. He wants you to believe he never did this, but he admitted to it to get his children back. First of all, again, that makes no sense. How would you put children back in the care of someone who just admitted they sexually abused a child? You also heard from Belinda that nobody took the children away from them. Santa took the children to her mother's house to get away from the defendant after he admitted that he sexually abused Nina. Ladies and gentlemen, use your common sense when you evaluate that confession. Does the defendant's story make sense? Or does it make more sense that he did that and wanted to confess to it? Everybody's been talking about failures today. And yes, Nina's been failed by all of the adults in her life. She was failed by the defendant, her stepdad, who sexually abused her and manipulated her family against her to the point where none of them believe her and are on her side. She's failed by her mother, who failed to protect her from the sexual abuse and allowed her admitted, confessed sexual abuser back into the home. And that was before the sexual abuse, the sexual penetration even occurred. She was failed by CPS, who, under the wrong assumption that Santa was going to protect Nina, allowed Nina back into the home. And they didn't follow up to know whether or not the defendant was back in the home. I'm urging all of you to not be an additional step of failure in Nina's life. She told you that she's okay with him getting probation.
Yes, I'm gonna object improper jury commitment. And the closing argument, John.
All right, overruled.
She said she's okay with probation because, like I said, she has nothing to gain. The defendant's already out of her life. What's the difference to her if he's in prison or not? But you don't have to consider that at this point. What I'm asking you to do is find the defendant guilty on all 5 counts and hold him accountable for his actions, which is what Nina said that she is still here 16 years later to do, even though she gets no benefit from this. Thank you.
All right, ladies and gentlemen, I'm going to let you retire back to the jury room. I'm going to ask for Alonso and Sosa, if you could remain behind, please. Everyone, please rise for the jurors. Please be seated. If I could see defense and state. Instructions still apply to both of you. You're not allowed to view anything. You're not allowed to start deliberating in terms of each other. Everything that you need to know about this case is come from inside the children. You won't be allowed to go back and them to deliberate either. Okay? So Deputy Laura's will let you know place to hang out. And then we'll call you if you're needed. So it's something where it happens to one of the jurors. Then we'll let you in preparation with them, okay? Yes, Deputy Laura will take you to get those images. Taking them back there to get their belongings. All right, thanks. All right.
I think Joseph.
Oh, and I found it in my purse. It was hidden.
I didn't like, I mean, it wasn't a problem. Well, no, I mean, just like I should have known that it would have taken more than 2 minutes so that I wouldn't feel rushed when I got my 2-minute warning.
Yes.
All right, Diane, are you ready? And then later, I guess you need to do the exhibits.
Yes.
All right. Oh, I'm so sorry, guys. Yes, she's going to give the exhibits and just remember 2 is not going back there. Yes. Oh, only 2A was at Bennett?
Yes, sir.
Oh, okay. Yeah. All right, Mr. Aguilar, if you want to come down. And then Hank, if you'll just ask that this be added to the STIPs. And has your client had a chance to see what's being added to the STIPs? Okay. 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 All right. All right, you ready? We're gonna go back on the record in 2023 CR 4007A, State of Texas versus Mario Aguilar. Can I have parties announced for the record for the state? Thanks. Okay, and with regards to the waivers and stipulation of testimony and stipulation state, any additions?
Yes, Your Honor, we would like to, add Stacy to the one to add the prosecution side, given the defense.
Any objection?
Your Honor, we have no objections.
All right. And you understand what's being added, Mr. Aguilar? All right. The court will find, based upon state's exhibits 1 and attachments and the stipulations what the court has is accepting the record, and the court is finding that the defendant has
Basically face down on the couch and the defendant was facing your back.
Yes.
And again, you're 14 years old at this time, correct?
Yes.
Father. When the evidence is gonna show that her father has been so.
No, this year.
How we live in hell.
December 2011, Richard Thomas hereinafter.
See if I remember them. All right, everyone, please be seated. And everyone, I'm sorry about the late start today. One reason why we had the late start, it had absolutely nothing to do with this case. I woke up this morning to a flat tire, and then I soon realized that cars no longer have an extra tire in it, not even the donut. So that took me a while to get that problem solved. And then I had some other cases that were unrelated to this case. So we're going to start, and if everyone can please raise your right hand for me. Do you and each of you solemnly swear or affirm in the case of the state of Texas against Mr. Thomas, you will a true verdict render according to the law and the evidence, so help you God? All right, you can lower your hand. State.
In the name and by authority of the state of Texas, the grand jury of Bexar County, state of Texas, duly organized, impaneled, and sworn as such at the May term AD 2021 of the 186th Judicial District Court of said county, in said court, at said term, do present in and to said court that in the county and state aforesaid and anterior to the presentment of this indictment, count 1, on or about the 11th day of May 2006, Richard Thomas, hereinafter referred to as defendant, did intentionally and knowingly engage in sexual contact with Nina Sanchez, a female child younger than 17 years, by touching part of the genitals of Nina Sanchez with the intent to arouse or gratify the sexual desire of any person. Count 2, on or about the 23rd day of December 2011, Richard Thomas, hereinafter referred to as defendant, did intentionally and knowingly engage in sexual contact with Nina Sanchez, a female child younger than 17 years, by causing Nina Sanchez to touch part of the genitals of the defendant with the intent to arouse or gratify the sexual desire of any person. Count 3, on or about the 25th day of December 2011, Richard Thomas, hereinafter referred to as defendant, did intentionally and knowingly cause the penetration of the sexual organ of Nina Sanchez, a child who was younger than 17 years of age and not the spouse of the defendant, by the defendant's sexual organ. Count 4, on or about the first day of January 2012, Richard Thomas, hereinafter referred to as the defendant, did intentionally and knowingly cause the penetration of the sexual organ of Nina Sanchez, a child who was younger than 17 years of age and not the spouse of the defendant, by the defendant's sexual organ. Count 5, on or about the first day of February 2012, Richard Thomas, hereinafter referred to as defendant, did intentionally and knowingly cause the penetration of the sexual organ of Nina Sanchez, a child who was younger than 17 years of age and not the spouse of the defendant, by the defendant's sexual organ, against the peace and dignity of the state, signed foreman of the grand jury.
All right. To those charges, how do you plead? Guilty, not guilty, or no contest?
Or the defendant pleads not guilty on all counts.
All right, is that correct, Mr. Thomas?
Yes, ma'am.
All right, State, do you have opening statements?
Yes, Your Honor.
All right, you may proceed.
Thank you. May it please the court, closing counsel, ladies and gentlemen of the jury. The story that you'll hear today is the story of a girl who came from a broken home. From the time she was young, she didn't really have a relationship with her father. And her mother, who was single at the time, began a relationship with the defendant, Richard Thomas, and brought him into their home. At the beginning, it was Nina Sanchez, who's the complainant in this case, and her sister, her younger sister, Jacqueline. Now, they didn't have a father, so they considered Richard to be their stepdad. And you'll learn how Richard Thomas used that relationship with Nina's mother to his advantage and took advantage of Nina, beginning from the age when she was 9 years old, and how the other adult in her life, her mother, continuously failed to protect her from the actions of the defendant. We anticipate the evidence to show that beginning around the age of 9 years old, Nina Sanchez was being touched in her private area on her sexual organ by the defendant. And you'll learn how his inappropriate touching of Nina continued and progressed as she got older, to the point where he had sex with Nina on multiple occasions. You'll hear how Nina's previously told this story to people. But because of that lack of protection from her family, she felt obligated to take back that statement, to keep the family together, and to protect her now two other additional younger siblings who were fathered by the defendant with Nina's mother, Santa, in order to prevent them from living a life without their father, just like she did. But you also hear how she's still telling this same story today, regardless of how old she is or how time passed, because what she told back then is a true story. And she was pressured to say it was a lie at that time. But you'll hear how her story has stayed consistent over this entire time period from 2007 through today. And you'll hear how greatly it has affected Nina, not just herself personally, but also the relationship with her family that's still fractured to this day. So we just ask you to listen to the evidence, take in the evidence, and we're confident that you'll return a finding of guilty in this case. Thank you.
All right, defense?
May it please the court,
Yes.
counselors, ladies and gentlemen of the jury. At this moment, I'd like to thank each and every one of you, because you are part of the process in which we started yesterday. My client has been waiting for this for a long time. Notice how the prosecutor said story. In fact, he said it several times, because this is what you're going to hear, a story. And I present to you that it's going to be a fictional story. And this is why. Nina started this long time ago. She's been telling people left and right. And the prosecution will have you believe that each and every one of those people ignore her. The prosecution will have you believe that her mother ignored her. You're going to see that time and time and time again, these people found that her story were lies. In fact, you're going to see for yourself that her story doesn't match. Contrary to what my colleague here said, her story has changed several times. If you remember back in the 80s and the 90s, TV station will have a show and there was a little ball that we have to follow and sing along. You all remember that? I'm going to ask you to follow the little ball. And this ball is going to be her lies. Because she lied and lied and lied and lied again. To the tune that sometimes everybody's so confused that we don't even know what the story is. It's if I will tell you a story, you tell him, so on and so forth. By the time we get here, complete different story. Again, notice that it was said a story, not fact, because there are no facts whatsoever to support her story. By the way, no forensic evidence. Supposedly there's blood, nothing, no DNA, no nothing of this alleged continual abuse. You heard that she tried to protect her siblings. Another lie. Why? She leaves at 14 years of age. Gone from her house. To do what? We shall see. Gone for 2 years. Where is a 14-year-old doing? The evidence will show what she was doing. Not being abused, but being actual consensually having sex with men. That's what she's done. And now, perhaps, she's having sex with other men and accusing my client simply because he's a strict father. Don't make no mistake about it. You're not going to do that here in this household. To protect her sibling, they say. And you're going to hear that she's actually having sex with her sister. How's that protection? Story. And in her mind, she believes this story. So much so that she has accused my client time and time again. CPS have been in their house so many times, they can't even count. And every time, ruled out. She's a liar. School, she's lied. She lied. She lied. She lied. That's what she does. Regrettably, all it takes is a statement for us to be here in front of you guys. And I hope and pray that each and every one of you will see that that little ball makes no sense. There's no tune to this story. It's a fiction in her mind because it doesn't coincide with the evidence. Notice that I'm not supposed to present any evidence because it's not my burden. But we're going to present to you evidence so you can see my client is innocent. He hasn't done anything other than being a loving father. And for that, he's been prosecuted simply because an unruly child wants to have her way. I pray and I hope that each of you see past that. Because scripture tells me that a witness tells the truth until they're cross-examined. That's what's going to happen. You will see how her story is going to change. And you're going to see how she's not going to know what came, because that's what you do when you lie. You have to lie again to cover the previous lie. You will see that for yourself. And I hope and pray that you do. Scripture also tells me that you shall know the truth and the truth shall set you free. And no, that's not the truth in this case. It's Jesus. But listen to this. When a person tells their side, their truth, it does not change. It just does not change. Oh, well, I forgot this year. Oh, well, I didn't say this year. Oh, well, I was. But in fiction, though, that's what happened. And that's what you will hear from Nina. Fiction. Stories that have no bearing to the truth whatsoever. And if it was so much so, her story would be backed up by the people that love her. People that at one time were against my client. They realized the true side of the story, her lies. You're going to hear from his spouse, the actual mother of Nina. You will hear from her. She loves her children. Trust me, when all this happened, started in 2007, you heard me right, this has been going on since 2007. You can do the math. It's been a long time. She was saying, you know what, kick you out, you out of here, go to jail, you can rot in hell, like any mother would. Then, reports start coming in. You know, this is not true. Ruled out. She tried again, kicked him out again. Report comes again. Nope, it's not true. Ruled out. How many times does my client have to go through this? And now she's going to come and testify and tell you the real side of the story. The story that Nina created in her brain, in her mind. She needs help. She truly needs help. Because the person that has all their factual attributes together, don't come up with stuff like this simply to get back at a stepfather. When the evidence is going to show that her father has been so reckless that even smokes weed with her daughter, even does things that a father will never do. Perhaps in her mind, it's part of the story. Oh, and me playing this guy because he's doing it right. My father, on the other hand, he's hot. You're going to see that. I'm not making that up. So, ladies and gentlemen of the jury, it is long time coming that the story stops right here. No more. I pray that you have the courage when you go back into the room and do your duty, because you said that you will listen to the truth and you will listen to the evidence and judge it. Please listen careful to Nina. This little girl needs help and she tells stories. Try to get back at my client, a person with no criminal history, nothing other than this mess, time and time and time and time again. This is why he decided to be here in front of you guys. You can put a stop to this story. You can put an end to this ordeal and this drama. Yes, the family has been destroyed, but it has not been by my client. In fact, all of them still together, all of them except Nina. The only one that have left since 14. Comes back and leaves again. Comes back, brings. That's her story. That's what she does. You'll see this. My client thanks you. I thank you. And our founding fathers thank you, because this is what they envisage when they say a jury of our peers will judge you. I pray to God that you listen to the evidence and you find my client once and for all not guilty. God bless you.
All right, State, call your first witness.
The state calls Nina Sanchez.